cell phones on, we can get this thing here started. Call this meeting to order. Would you rise for the invocation by Ms. Jones and remain standing for the pledge of the flag?
Dear Heavenly Father, we thank you for this time together, that we can come together and attempt to do the people's business. We pray that you will be with us and lead and guide our decisions, and give us wisdom, and help us in your name, we pray. Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
First item on the agenda, please, is the consideration of a resolution to approve the agenda. I have, we got that information.
Should be up there.
It's here.
Yes.
I have one thing that's been asked to be added to our agenda, and as a consideration for funding. So, I guess the drug court?
Correct. What we've been asked to do is to adopt a resolution for funding.
Neither of those parties are here presently, right?
Correct.
So it would not matter whether we put that on the agenda first or last.
Not at this point, that's, unless they walk in any minute.
They may. I received an email from Back Mosley inquiring, so she may be walking in. Sure.
Okay. Well, I'm asking that item be put onto the agenda.
What is it?
Is it this?
Cool. Juvenile court.
List of purchase items for courts. Is that something second?
That's a portion of it, yes ma'am. There should be some other documentation. There should be 2 resolutions and a string of emails between the attorney and myself.
It looks like this.
To add to the agenda, the item of a resolution for consideration for funding of the drug court programs for Effingham County. And ask that we consider this by Judge Turner. Other than that, I have no recommendations for addition.
We want to add that as new business, fast.
Let's put it as number 11 and then
Number 11.
How do you make that motion? Make a motion that we approve the agenda with adding as new business item number 11, the request from the courts for a resolution.
Second.
Motion and a second. All in favor? Any opposed? So carried. Next item is a consideration to approve the minutes for the September 10th, 2013 short-term work program workshop and the minutes of September 10th, 2013 commissioners meeting. Motion and a second to approve. All in favor? Any opposed? And so carried. There are 2 items on the consent agenda. First item is consideration to approve an assemblage permit for a turkey shoot for Albert Jackson located at 187 Church Road, map 366A-17. approve an assemblage permit for a turkey shoot for Jack Burnson located off of Lubbock Road, map 376-9. Before I ask, these items went through the planning and zoning, right? Or is it necessary?
It's not required.
It's not required. I have a difficult time asking for a vote on these items without listening to anybody's public comment. So if there's anyone here that wishes to speak to either of these items, I will entertain that information. None being presented, I will entertain a motion for the consent agenda.
Make a motion to approve.
Second.
A motion and a second. All in favor?
Aye.
Any opposed? So carried. First item on new business. Consideration to approve an assignment modification to the Staffordshire reuse agreement. Mr. Leotis.
Thank you, Chairman. Staffordshire Estates, it's a subdivision off of Blue Jay Road. You're probably familiar with it. It's an existing subdivision. It was originally planned for 148 lots. 87 lots have been platted to date. The subdivision is on county water, sewer, and reuse. There is a area under the power line easement that is being used as a reuse irrigation area. I'll try not to use the word disposal, but they are taking irrigation water, taking our reuse water at that site. The irrigation system was constructed at the developer's expense, and the area that they use is far in excess of the amount needed to take the reuse from that particular subdivision. In other words, the reuse area can use about 230,000 gallons a day of water, but the subdivision, 148 lots, would only create about 44,000 gallons of wastewater a day. So in other words, they in essence created us a large additional reuse irrigation area over and above what's needed for their particular subdivision. And because of that, back in 2007, the board approved an agreement for reimbursement, in essence, of the costs of constructing that reuse area. The agreement is kind of complicated and long. I believe you've been provided a copy of it. But in essence, boiling it down, what it says is that the reuse fees for the 148 lots proposed in that subdivision would be waived, and credit would be given for the excess capacity over and above what was needed for the subdivision. So for that additional capacity there, the 185,000 gallons worth of additional capacity, you would actually reimburse based off of fees paid by houses constructed in other subdivisions that don't have reuse areas. Long story short, that's the sort of where it lied for several years. I did want to mention that the agreement can have language that prohibits assignment, so it can't be assigned without the board's approval. Mr. Emmerich, Alan Emmerich, has been one of the owners of Sly Land Development, which is the company that did the irrigation system and is the user under the user agreement. He did previously have a partner in this particular agreement, but I believe he understands that he is no longer in partnership with this person. And he has made a request just a couple of weeks ago that the agreement be assigned to him personally, not to Sly Land Development. He didn't really explain why, and I really don't want to try to speculate as to why. He did mention that there was going to be some sort of separation regarding the ownership of the development between himself and the bank. I tried not to get into his personal business as best I could. But he wants not only the agreement to be assigned to him, but he would also like to convert some of the lots that have waivers of fees, in other words, some of the ones in Staffordshire, but not all of the ones in Staffordshire, from waivers to reimbursement. Now, from the county's perspective, that means really nothing. We're going to take in $1,300 and cut a check for $1,300. It's really no different than a waiver from the county's perspective. It just depends on who actually cuts a check to pay the fee and who gets the reimbursement. Under a waiver type system, the assumption would be that the developer that is the developer of the subdivision is also building houses and would want to pay the fees and also would then recoup the benefits of the waiver. In this circumstance, that's in essence not what would happen if the board was willing to move forward with some sort of amendment to the contract that would allow those fees to go, some of those fees to go from waivers to reimbursement. Now, he does want the lots in phase 2 to continue to be waivers. A lot said there. I apologize that this is rather confusing. It took me quite a while to process what it is he is trying to ask for, but I do believe you've been given a copy of his very short request statement. And at that point, I really kind of like to open it up for questions and try to see if everybody's on the same page regarding this.
Well, personally, I don't understand
Yeah, I do.
at all.
Well, I'm
And
not-
the next thing is, I would have to ask our legal staff to, if there's an agreement with an entity that is separating, what would we need to protect ourselves to be sure that we're not assigning this to an individual and bypassing another part of,
Well, from what I understand and what I got from the staff report and Steve's documentation is the entity and the individual are essentially the same person, but there is no partnership.
He had a partner, there's no person involved.
He had a partner at one point. My understanding is that he no longer has a partner, but I certainly do not know the intricacies of his
But the
LLC.
partner had rights to this contract that we can't dissolve.
Well, then we would need to see some sort of, dissolution of the partnership agreement or, some kind of proof that the partner is no longer involved before we assign it to the individual.
No, point being, and one just clarification, we don't actually assign it. We give permission for him to assign it, but
Right.
understood. Go ahead.
Sorry, that's what I meant.
Right. Yeah, understand.
But additionally, I would say this, I think this item needs to be tabled until we get more information from the attorney, because there are some questions in general that maybe this would have come up if it wasn't being asked to be reassigned, but since it is being asked to be reassigned. I was able to ask Steve right before the meeting, because I did want to be sure I understood. I'm pretty familiar with the water and sewer, but the reuse is a little bit different, so I wanted to understand what the reimbursement was for, because I recognize it's over $700,000. And it is for a reimbursement of the cost to construct the pipes, the reuse pipes, that is part of a system improvement that other places benefit from by doing that conservation of water, basically. And so with that being said, there's 2 or 3 things in there that, one, it would seem to me the original contract should have had to comply with the multi-year terms, and I want to verify, because I don't want to renew something or extend something or change something. I want to verify that it's accurate to begin with, or do we have any liability in allowing it to continue that's brought before us in some way to change if it wasn't. And then also even the fact that it wasn't publicly bid out, there's some things in there, so, and I'd like to verify those things.
And that's all stuff we can look into. What's before the board at this time is whether y'all want to reassign it or not. And
But I don't think we should reassign it as
right,
issues. So I think we should
if
take
that's the case, then it should be tabled and we can look further into this issue.
Are you clear on exactly what
Yes,
needs to be looked into?
yes.
well,
Sure,
at
please.
this point, I agree with Commissioner Jones that there's a lot of questions about this, but right now, they're disposing of our reuse water.
Correct. This reuse water is being irrigated or disposed of on the property, yes.
Does the county have a need for them to continue to do that? Because you're talking about they're wanting to convert part of that site into lots, am I correct?
No, sir, not in any way. As a matter of fact,
I missed something.
okay, yes, sir. It does not say that in any way. The reuse irrigation area is not being proposed to be converted to lots in any way, shape, or form. As a matter of fact, county has an easement to operate that system and operate and maintain that system. That property can't be converted to anything else.
So the county asked him to do this.
Well, no, he volunteered to do this. I mean, this wasn't something we asked him to do, but he volunteered. He basically said, I could create a 5-acre irrigation system on my property to handle all of the reuse water that comes from my development. So therefore, my development wouldn't have to pay the reuse fee for the reuse water to be disposed on somebody else's property. So he went back and looked at it and said, well, you know what? I got all this area under the power line. It's about 24 acres. I could do the whole thing and provide you guys with additional capacity over and above what's needed for my development. And the board agreed that that was a reasonable thing for him to do. We'll always need more and more and more and more reuse disposal capacity as time goes on. As more people tie into the system, the water has to go somewhere.
So we're reimbursing over 700,000 for the pipes that he laid.
Because that became part of the system improvement.
In essence, even though this is not impact fees, yes, you could look at it as a system improvement or in that same sort of vein.
Well, I apologize because all of y'all have been at this longer and smarter than I am, but the power company,
It's actually two reuse systems in a subdivision like this. One is the line, is the system that goes to the treatment plant, and one is the big system improvement that we're talking about. It comes back from the treatment plant and is sprayed out in that area out there.
And we do need.
And all the area we're talking about is underneath the power line.
But he's trying to change the agreement so that he personally reaps all the benefit and change some of the lots, if I understand, so that they weren't gonna pay a fee, but now they will pay a fee and it'll go to him.
Yes, in essence,
In short.
the checks currently go to Slatland Development. My understanding is he cashes the checks personally and is receiving the money. So really, from that perspective, it's not really changing anything fundamentally from that perspective. But yes, some of the lots that are currently platted are currently, well, all the lots within that subdivision are currently under waivers. But he would like for some of those lots to be converted from waivers to actual reimbursements. In other words, they pay the fee and he gets the actual check. So more money for him.
He would rather sell it as though the county's gonna collect this and you'll get from you when he sells the lot, rather than just go up on the price of the lot.
Or in as much as my understanding is this has to do with something between him and the bank, he may actually no longer be selling the lots. It may be going back to the bank in some way, shape, or form. Although I don't.
It's a sign the agreement and change it. is what we
He's made 2 requests in his letter, that's correct, that we assign it to him personally and that we modify it to change these few lots from waivers to reimbursements. Now, obviously, we could do one or the other or neither, or both, which, I mean, there's several obvious alternatives here as to which ones you can mix and match or approve one and approve not the
Or
other.
if we have something approved that the partner's out, we may still feel we owe him for something and do a different thing. If this doesn't meet a certain thing.
It's up to the board. It's complicated.
I agree, I think we need to table this, make sure that he can do this. If something proven the partners are gone, he's the only one left, and that kind of stuff, and then.
So basically, he's providing above what he would have paid $192,000 in reuse fees.
$1,300 times
reuse
148.
disposal.
Right, he could have paid a fee.
Yeah.
Or, well, it wouldn't have been, he wouldn't have had to pay it individually, it would have been paid as the building permits were issued, but yes, sir.
$15,000 credit.
Correct, there is a,
Right.
right. What it is in essence was originally done, and then, right, the amount of money between that amount, the 115 or whatever that number is exactly, up to the 700,000 would then been reimbursed from other lots and other developments that don't have reuse capability and therefore pay a fee.
He's actually being reimbursed from other developments that didn't provide reuse.
Correct.
That's what the contract says, but in some cases, he's probably also been reimbursed from developments that did provide reuse.
I don't believe that's the case, but I mean, we are very careful to go through the list of everything that pays the fees, and the ones that pay the fees are the ones that don't provide reuse.
all right. I'll entertain a motion to table, number 1. And the next thing is, in tabling it, we need to be sure that they have the information they need to bring back to the board,
Yes, please.
so that we can properly consider it.
Absolutely.
And we're going to table it, I'd rather table it to the second meeting in October rather than to the first meeting to give us adequate time to get that done. I'll entertain that motion.
I make a motion that we table this item to the second meeting in October.
I'll say.
Motion and a second, all in favor? Any opposed?
Is there anything else you want from me, just this clarification from the attorney regarding the partnership? Just make sure.
We're going to get you some more direction.
The thing that I asked, and if you need something, bring in an email or something, let me know.
I can clarify what Zira asked, but what we'll need from the developer is some sort of proof that the partnership has been properly dissolved and that he is in fact the only entity left in what was the partnership, so that if the agreement can be assigned, that we can in fact assign it to him personally.
I will tell him that and have him provide that to us, and I'll forward it on you.
And then if this board approves that, then we'll have to go through the information of getting his personal information, how to set him
again.
I think this is the piece of property that staff reports gave us a little inkling of last
Yes.
time.
Yes, sir. This was mentioned at last month's committee reports. I understand that Mr. Floyd had some input on this issue, so I won't try not to spend too long on this. But in essence, make a long story somewhat short, back in 2011, Mr. Larson came into my office, actually into the zoning office, talking about purchasing this particular property that we knew of as Winfield Phase 2. He spoke to the zoning administrator at that time regarding putting a home on the property and using it for agricultural pursuits, specifically for cows. Mr. Shaw informed him that that would require rezoning. While he was in the office, I did have a chance to speak to him and inform him regarding the water and sewer that was present on the property, and also informed him regarding the county ordinance. We actually had a conversation regarding the lift station, regarding the manholes that are on the property, and et cetera. So I do recall that really quite well. In August of this year, August 27th, Mr. Larson applied for a building permit. As per our normal procedures, the building permit application was routed to me for approval. I did approve it and noted that water and sewer was available on the property. So therefore, it would go back to the building inspector's department with the instructions to collect the water and sewer fees that would be necessary for the tie-in. I gave Mr. Lawson a call personally on the 28th and informed him of that approval of the of the application, and then also provided him with a map of where the water and sewer lines were on the property on August 30th. He did subsequently come in my office and tell me that with his wife that he didn't want to connect water and sewer. They didn't want another monthly bill, and that he also had gotten some preliminary estimates of the costs of what it might take to run the piping from his preferred location for the mobile home to where the water and sewer lines lie. And he did state that was basically more than he wanted to spend on those lines. He did mention that he was willing to relocate the home in some way that might somewhat reduce some of the costs. If you can move it closer to the sewer line, that might reduce some of the costs involved. I told him obviously that would be perfectly fine, and that we would, for the fees that are being requested, obviously the standard tap-in fees, do require the county to perform the tap, to install the water meter, and to also install the sewer tap. So all that Mr. Larson would have to do was basically connect from wherever he chooses to place the structure to the water line and the sewer line taps that we would do for him. We put them obviously as close to the building as humanly possible so that we could minimize his costs. We certainly wouldn't do it farther away from the property if that was necessary. So just to be completely clear about where the water and sewer lines lie, there's the 16-inch main that runs right down Highway 30 on the same side of the road as his property. It's currently in operation. It's providing water to customers. The convenience store at Javits Jones, for example, the first phase of Winfield, obviously. There's also a gravity sewer line that runs right through the property through an easement, and that does convey the sewage from Winfield Phase 1 over to the lift station, which the county does, I believe, own. We believe we closed, if my understanding is correct, on the purchase of that lift station from the bank. So that is a county lift station there on a separate parcel of property now it's been subdivided. County Ordinance 75-1 has been in existence since 2003. I believe you guys were provided a copy of that. I believe you were also provided a copy of the state public health rules. Public health rules do preclude the issuance of a septic tank in this case, septic permit, excuse me, because of the availability of gravity sewer. And the health department, I understand, has basically discarded their application, for lack of a better word, because of the issue with sewer being available. They cannot issue a septic tank permit. I do want the board to know that this situation is somewhat different than a couple of other things that have come before the board in the last couple of years regarding these. In this case, both the water and sewer lines are currently operational, as I mentioned before. We're providing water to customers. We're collecting sewer from customers. They're completely operational. It is a gravity line. And in this case also, there's never been a well and septic on this property. It's been vacant. So it's not as if there's an existing well or septic that could possibly be used for that exemption that says we don't make folks tie in when there's existing well and septic. I believe you're also provided with some information that Mr. Larson gave. I believe it was given to Mr. Floyd and passed to us. There's an estimate that he put together, which I believe is his opinions of what it would cost to connect. I do want to point out just a couple of minor inaccuracies there so that the board doesn't misconstrue that statement as fact. There is no such thing as a water meter install fee that's listed on his estimate. We install meters as part of the meter fee, not, there's no separate install fee. He's also listed the deposit, which is a deposit, not a fee. It's refundable, so it really isn't something that would be normally included in an estimate of cost for connecting. The estimates for the well and septic don't include water and sewer lines from the home to the well or to the septic tank. He's including those in the estimate, obviously, for connecting county water and sewer, but not in the estimates on the well and septic. Obviously, well and septic have to be separated by at least 100 feet, so you're going to have at least 100 feet of connection property, and depending on where the property is in relation, where the structure is, in relation to the well or the septic, could be more. And then also, I did speak to the health department, and their recollection of the soil study that was submitted as part of the original application was that there would be some requirement for dirt to be brought in because the soils weren't exactly what was necessary. So the amount that is listed on there, I believe, is something like 2,400. Their opinion was that that was a vast understatement, that it was probably at least $4,000 to $5,000, if not much more, depending on exactly how much dirt needed to be brought in. I do want to mention that Mr. Larson's estimate does include something called, that he refers to as a hybrid option. That hybrid option is a private well and county sewer. I do need you to know that County Ordinance 75301C has been in place since 2005 and requires that residential units that are on private wells use private wastewater system, and that private residential units connected to public water must use the public wastewater system when available. Now, keep in mind that only applies to the residents. We're not talking about use of a private well or a shallow well for the irrigation of cows or anything like that. Obviously, that can be done. There's no regulations against shallow wells in any way, shape, or form. And do keep in mind the reason why we require everybody who's on sewer to also be on water is that we can't functionally charge anyone for sewer if they're not on water. The ordinance clearly requires that sewer be charged by the amount of county water used. And there is also an implication to that. If we were to allow someone to be on private well and private well and county sewer, since there's no regulations on private wells, pretty much anybody who's on county sewer at this point in county water could disconnect from the county water and install a well and continue to be on county sewer. That would be very problematic for the financial situation of the water and sewer system. And finally, in closing, I do want you to know that obviously there is a vast spectrum of amounts of money that it could cost to connect to water and sewer via the connection piping based on the location of the structure on the property. Obviously, it's a large property. And one end of the property on the western edge, the water and sewer lines are fairly close to each other, within at least about 350 feet of each other. At that end of the property, water and sewer actually could be connected at basically exactly the same price as what it would cost for any other residential structure, any other residential subdivision in the area of $7,500 to $8,000. Obviously, as you get farther to the east, where those pipes diverge, obviously it's going to be more because there's more pipes installed that would be necessary to connect to the water and sewer lines in place. But in no way do we require any particular amount of money to be spent. You can put the structure anywhere on the property and basically pay anywhere from a normal amount, $7,500 to $8,000, up to tens of thousands of dollars, depending on where he chooses to place the structure. I do also understand that the attorney provided, Eric actually provided a legal opinion regarding this. It was fairly lengthy. I certainly won't read it to you. You guys let us know if there's any particular legal questions. I'm certain that Elizabeth, you are familiar with what Eric has already provided, obviously. So at this point, if there's anything I haven't covered, please let me know.
Bottom line, if this board does not require connection, we would be going against our own ordinance, correct?
The ordinance implies that there's a presumption. If there are water and sewer, if water and sewer is available in the right of way, then there's a presumption that it's available. And if a landowner wants to rebut that presumption, they need to present evidence that it is not available. And I'm not sure if Mr. Larson was aware of that or not. I'm not sure if he's here tonight. But in our opinion, I don't think that the sheet he provided is really enough evidence that the water and sewer is not available. I think at a minimum, we should be seeing, some kind of contractor or engineering estimate stating, exactly how much it would cost for him to connect if he was to looking at septic permit, I don't believe they legally can, given the state regulations.
The fact that the sewer line is obviously available, I mean, it's
The,
there and functioning, yes, sir.
I think there's a presumption also that when this ordinance was written, I don't think it was geared towards large tracts of land. And Mr. Larson is here, and I think I'd like to hear his side of the story as well.
Michael Larson, the owner of the previous Nolan Winfield Phase 2. I did put this estimate together. I got this from Heck Plumbing, one of the local plumbers around here. The original estimate he originally gave me, because it's about 1,000 feet of water line to tap in, was $3 to $4 a foot for water line is what he was running. When I asked him about sewer, the original estimate was $12 to $15 a foot for sewer. I got 650 feet of sewer was where I was looking at. When he came back to this estimate, which is I think the one you're looking at now, I think it's the one that I gave Mr. Floyd, is it comes out to about $3.25 a foot for water, and it comes out to about $9 a foot for sewer. So the estimate was a little high that he originally gave me. Didn't know about the $100 water meter install fee. That's off the website and off the code, all the fees that you read, which is thoroughly confusing, but that's why I got that. I understand the deposit fee. Bottom line is it's almost twice the difference for me to put a septic. I talked to Breland Well, and that was a connection to the house. And I talked to Ron Septic over here for my estimate on the septic tank. And I do have a level 3 soil report that I used and got the estimates. I got a copy of it here. I also gave it to the septic department when I turned that in. They had a copy of it, made some copies, but I still have the original, if you'd like to see that. So that 24 and 41 is fairly accurate, but it's same thing as the other part. The other part we're looking at that I'm kind of nervous about, and I couldn't really find anything on the website in the county here, but I searched through and I found some stuff in Wisconsin and Virginia. If you start looking at lengths of pipe and the pressure on the main and the size of the pipe, for me to maintain the pressure, because the pressure over there is between 50 and 55 PSI on that water main, although it's a 16-inch main, I'm probably going to need to use, and I'm not an engineer, this is just me trying to learn on the internet to figure out what I got to do so I can maintain pressure in my house. With 1,000 feet, I'm probably going to have to use a 1-inch meter. So the $500 meter fee on there is for either a 5/8 or a 3/4 inch meter, but I'm going to probably need to go to a 1-inch just because of the difference of GPM that I would put through before you start getting fluid loss. And I'm going to have to run a 2-inch line all the way out to the house. So when my wife and I looked at this and saw how much it's going to cost, we tried to figure out what we could do to reduce the cost. So I did come up with a hybrid plan, move to the south end of the property. Well, by moving to the south end of the property, I'm running about 1,900 feet of water line. Because it's the north end of the property is the water, the south end, as explained, is the sewer. Looking at 1,900 feet, it's still around 3 1/4, but it saves me another $1,000. Because I can do a septic line for about 100 feet, and it'll cost me about $15 a foot at that point at $1,500 to reduce the cost. And that's when I wrote down the hybrid plan of putting in a well and a septic, or a well and using the county septic. The other option that Mr. Leo brought up of moving to the western end of the property really isn't, because there's 2 high Georgia power lines down there. That's the reason we're staying up to the eastern end, is because we don't want to be living underneath the power lines. So it's really not an option as far as I'm concerned to live over there.
Let me ask a question. Can I interrupt you?
Yes.
And maybe cover a couple of things that we can get into and see if it's helpful at all. Because these are a few of the things that I'm feeling and thinking, and I want to see if they seem reasonable. Our county policy basically does say that you have to use us where water lines, where such services are reasonably available. And it goes on to explain that, generally speaking, it's presumed that it's reasonably available if it's on a right of way or within 200 feet of the property line. So it's almost as if what Forrest was saying when he's saying we didn't take into account the acreage, the large acreage. Generally speaking, in most cases, if it's on the property line, it's not going to go further than the 200 feet. In his particular case, it's exceeding that 3 and 4 times that. So it may seem, in my mind, reasonable to assume that it is not reasonably available to him based on the distance. Because it goes on further, you know, there's precedent by state law that says it's presumed that if it's a forced main and all this other cost is going to be involved. And that's what he's saying here, in order to get the pressure that he's going to need and to run at that distance for one residence, because there's also an additional place where it talks about, you know, it's for one residence on forced main. So if you're trying to serve one residence and it's going to cost that much to actually service it properly, to me it would seem that it could be something the board could determine that it's not reasonably accessible for him. That's an opinion.
Don't you also have?
There's also another code, 75-301, that we talked about that says if it's over 1,500 feet under private well use, if it's over 1,500 feet, it's no longer reasonably available. So, but my understanding is that that doesn't apply and it's no longer a valid code.
That's correct. It's not a valid code. And just to be clarified, it's not a force main. This is gravity sewer.
I understand that. I said that the code reads about the force main, but
Yes, ma'am.
to
In
me,
relation
it
to
makes
sewer,
sense-
yes, ma'am.
It makes sense when it has to go that distance still, even with gravity, that we may be able to presume that it's not reasonably there.
Well, and that's a decision the board needs to make. Whether something is, you know, going to be economically more beneficial one way or the other, that's y'all's decision to determine whether it's reasonable for him to pay his fees or not.
Is the benefit of this one customer reasonable for us to have him expend that additional cost? And there's extenuating circumstances also to this it's actually not in our book, but based on trying to understand what's going on here, if I understand correctly, there is a question mark as to if we even own the lines.
That we own the pump station, but we own lines to the pump station. It's on the property.
And it may be beneficial if that extenuating circumstance does exist, that we work with the citizen to actually get him to sign a deed to give us title to our lines that we need and not make a requirement.
I can't speak to the information whether we own the lines or not.
That was something I did ask for legal verification on, I can tell you.
So if this board was to take action not to require Mr. Larson to connect water or sewer, what are you going to do about a septic system?
I'm going to put in a
Do you
septic tank.
think you're going to talk the state into waiving their rules, allow you to put?
We have to deem it feasible.
We would
For
deny
the state to
We
do
just
that.
say that we presume that it's not
That's damn
reasonably,
feasible.
not reasonably available.
And then they would issue him a
Yes,
permit?
that's what happened with the Lutheran, my Lutheran church.
Did you say you already had a perk done?
Yeah, I do. I have a perk test right here with this with the stamp on it. If you'd like to. Obviously, I got to keep it, but I do have copies of it also.
I'll be surprised if there's a problem.
And it does talk about is the soil suitable for installation on site and all that. And what he does say is I need about 6 inches of cover soil on top of it. Is what he talks about, which is talking to Best Inc. Mr. Bradshaw that did the test. That's the norm for Effingham County. There is nothing unusual about anything that's out there. And I could probably dig out of one of the pits over there and haul the dirt over and drop it on there. I don't even need to truck that dirt in. It boils down to it. I guess it was my misunderstanding back 2 years ago when I bought it and I talked to Mr. Leota, because there was a lot of things going on with this piece of property that I missed the whole part about hooking up to sewer and water. So when I put my permit in, I put it in with the level 3 support already done, because my assumption was I was gonna be able to put it right on a septic tank and a well. That's why I had the estimates done there, and then I had to kind of get reverted and try and get these other estimates completed. I guess what I'm really asking is that maybe they relook the whole municipal code when it comes up to this.
Is the sewer within 200 feet of the property line? I mean,
It's on the property.
It's an 80-acre piece of property there.
It's only right.
But he has to run it more than 200 feet to get to it. It's 85
ordinance clearly says that, and it's clearly within the 200 feet rule and stuff like that. We have to deem it infeasible, but I still don't know that the health department can
Right.
allow it. But that's,
I mean, the board can find it feasible or not feasible, but we can't control the health department. So,
Well, that was my question. Has anybody asked the health department, are they going to give them a septic permit? And the answer was?
So I think
in the church deal that we did,
Right here, Mr. Chairman.
I can't see
Okay.
it. I
In,
don't know.
I'm
in
sorry.
other words, they're saying if this board of commissioners deems it to be,
The board writes that letter,
the board writes a letter
and he'll issue
and
a permit.
says that we're not going to require it, then they will issue a
but
permit.
it says that is not available. It is available. It's just,
Is it
we're
reasonably
going to have to
available?
deem it as not cost effective for the city. That's what we're going to
I
say.
think we can have
Because
it
it is
I
available.
think reasonable is a word.
reasonably.
It's not reasonably available. If the board denies them, again, that was Mr. O'Neill's response. He doesn't say exactly how. He just says if the board decides to usurp the regulation, their decision must be by the office of writing before we could issue a septic permit.
If we write a letter that says it's not reasonably available, and then they still deny, which nothing we can do about it, you'll have to deal with them at that point. That would be,
But it is reasonably available to the property. It's not reasonably available to where you want to put his house.
What if it's 1,000 acre tract?
That's-
You know what I mean? Where
We
does
got-
What I'm
we need to
saying
change
is
the
the
ordinance.
ordinance is the ordinance. This board is going to need to take up the issue and
We
rewrite
need to change
the
the ordinance
ordinance.
to say if
The
you must
ordinance
tie
is going to
in.
have to be changed.
Yeah, we just need to change the ordinance to say you must tie in if you want to.
what is your timeframe on this?
Currently, I've got I'm gonna call a guy tonight to pour a pad for the mobile home. The house is sitting in Statesboro completed, waiting. I've delayed it a week already for the install just because I don't have, I wanna go and buy the building permit, spend, I'm not really sure how much it's gonna cost. You know, $5,000-6,000.
So you have a mobile home ready to go put on there.
Yes, sir. I got, Mr. Diggers is waiting for my phone call whether he can start running the pad tomorrow. That's where I'm at with my house anyway.
I agree with Mr. Leo that there is no way that this county could give you access to sewer with your hybrid and you put in a deep well. The state will not allow us, and correct me if I'm wrong, but if you didn't pay your sewer bill, there's no way we can cut your sewer off. We can cut your water off, but we can't cut sewer off. It's against the law. Plus the fact there would be no way under our fee ordinance to even know how to bill you, unless we were to come up with another scenario and say, okay, we can put a meter on your well and then gauge how much water comes through your well. And then charge you for the sewer for that. You wouldn't want that because then you'd be paying all that, so.
Well, the reason I asked about your town situation is because if you're talking about moving a mobile home, I don't know what your current living arrangements are, but is it something that you could delay while we actually take up the item of tweaking the ordinance, which I'm not sure how many weeks that would take, but can we do that in the next meeting or what
Well,
meeting?
then you have to have a first reading and a
A
second.
second
Once you did 2 readings at the same meeting, correct?
Yeah, two readings at the same.
Yeah.
Okay, depending on
Normally it
how
would take
much
us a
you want
complete month.
to tweak, you know,
And there'd be no guarantee, as to what
We're
would
not
happen.
issued a letter with giving staff direction that we're gonna work forward to write or correct the ordinance.
Well, you see, the state, and here again, correct me, I think the law, if I understand it correctly, used to state that if a county or a public entity ran sewer and water in front of your house, you had to connect to it. And that was changed in Georgia to where I think the only way that you could be forced to connect to the county's water and sewer if you already had existing service was if your septic failed or if you didn't have an adequate water supply. If it failed, then you could be made to connect. So here's what the state is using, I think, is their rationale for saying we can't issue you a permit for a septic system because you already have access to public sewer. and you don't have an existing system. So I think they're by their law, and we have an ordinance to deal with. So this board is going to have to either decide to turn their face to the ordinance or rewrite it in some fashion.
So I'll tell you, if it was $4,000 or $5,000 difference and it was me, I'd rather have the county water and sewer than have to deal with the septic tank and the well issues and such as that. And with that, I've got a question on,
I think his rates are low.
on these rates and stuff. I think your septic tank, I believe, is gonna be a little bit more. I think a small well is not gonna be equal to what a 2-inch water line will do. But in these numbers that are given to us, and you said at $325 a foot that you're pricing for 2-inch water lines, you got 1,900 feet at $8,000.
No, it's 8,000 for the sewer and the water. That was a total for both.
Okay, so your water and sewer is your totals there?
Yes, sir. That is a both. And part of the other problem, and it's definitely a unique piece of property, but as you took the lift station over, I was hoping there was water out there available, because most lift stations should have water. Otherwise, you have to haul it out there to take care of the lift station. And there is a spigot over there for water, but there's no water because I didn't run along with the sewer main. So
And that would have been in the.
that would have been the option, that if that water was there, I could be 100 feet away, I could plug in and there'd be nothing to it. But the problem is because the water's at one end and the sewer's at the other, it's just causing a headache.
Is that
So,
correct, Steve?
My question to the county was, are you ever going to run water down there? Because if you're going to run water to that lift station, I would feel free to tap into that once it's available. And that would be reasonable available to me. That's my assumption, kind of that. There isn't a real good definition in the codes for reasonably available, but I think cost is something that we consider reasonably available.
So when in the Winfield deal, when we close on it and all, do we have access to the station in the legal closing, right?
We bought the station.
The lift station.
I mean, I don't have the documents in front of me, but
What I was questioning was, we bought the station, the lift station, but there's a question mark, as to my understanding, as to the sewage pipes that run down the middle of the
So
property.
there's got to be an access easement to something we own in closing.
I don't know what the access is. I mean, you look in the property, the plat, and there are access lines on it. Easements that are drawn into the property. As you can see up here, there's numerous easements on there. The one that kind of goes to the middle of the property is really the sewer, that's approximately 80 feet wide. You can look to the right side and see where the lift station is, where it says parcel 2 point something acres. There's the lift station, and then there's the easement runs all the way up into Winfield subdivision over there on the left. On the furthest south side, so that's where the sewer's at, and on the north end where Highway 30 is at, that's where the water's at. And on the far east over there, that's where those power lines are at that I really don't want to be next to. And the very south is actually a storm sewer, which the lines are not quite accurate for that easement either. And I'm not really sure they need 80-foot easements over there anymore if it's not going to be into a subdivision. But once again, I don't have any issues working with the county to figure out the right way to do this. I really don't want to go hire a lawyer and get into a whole big mess. I want to find out what the right thing is and just take care of it.
Would we charge him to tap it? If those are his lines, would we still charge him to tap into his own line for sewage?
Now is another question. I mean, if that's my sewer, then why are you charging me to tap into it? And why am I getting paid for all that stuff running through?
To me was, why did you buy the pump station? Why don't you buy all this other infrastructure for me? This is a much bigger issue than a well and septic tank.
This is just my first step. I started getting familiar with it.
But that's not even including the storm system.
There's a couple of issues. Obviously, that's the lift station. This 80-foot easement is where the sewer runs from phase 1 into the lift station. There's a pond that's actually not shown in this area. There's drainage that comes from the road here into the pond, back out, and then there's a pond here in phase 1 that drains back through this easement. There's a closed drainage system that comes all the way down off the property. Part of those show easements, part of them don't. In the deed for phase 1, when the county accepted that, and this is phase 1, when we actually took the roads, you'll notice that this one here, we actually took, doing this upside down, detention ponds. So we own the ponds within phase 1, which drain through phase 2, which have no easements on them. So if Mr. Larson were to decide to fill that pond in or take these pipes out, we would have some issues within phase one.
Which are the extenuating circumstances I was referring to? That-
So there's certainly some easements that need to be cleared up within this particular property. I don't know, Elizabeth, if you had really a chance to look at, does this convey rights to the county just because it's shown on this plat? I don't know legally if that does or not, but I believe Mr. Larson's expressed a willingness to work with the county to resolve some of these issues. It's just a process we need to go through. In reference to and I've never seen the closing documents on Winfield, so I don't know the answer to that, but I believe we closed off of this plat, and I don't know that there's any access easement shown on this plat, so it's a good chance we don't have access to that lift station either. So there's a number of issues that we certainly need to clear up with Mr. Larson, going forward.
I am giving the county access to that lift station, and they've been going there for 2 years, and I've been talking with those guys out there on numerous occasions. I did talk to them about that sanitary sewer. There's a bunch of manhole covers that weren't there. They put 55-gallon drums on them, and one of them was filled up with garbage. So I kind of went to the guys and said, hey, is there any chance we could put something else out here? And the county came out and put, sanitary covers, actually, the correct ones on there. So guys can't just go lift it up with their finger. It's going to take a little work. I've done a lot of fencing around there to keep people out of it because there's a lot of mischievousness going on there. There's a bunch of 4-inch sewer pipes sticking out the ground along that entire easement, and I can't really tell you, but somewhere between 20 and 30. And guys that went through and used them as target practice, they just run a bunch of them over. So, not really. And I've tried a couple of times over the last couple of years trying to get a little help and trying to figure out who the right guy is to talk to what to do with that. Because I'll figure out how to bury them things because I don't want them to get wrecked. This is an investment property for me. There's no, I'm not trying to hide that. If it's not for me, it may be for my kids someday. But figure out how to bury these things correctly rather than just run them over, and let them fill up with dirt.
Basically, they could be cut off at almost dirt level and capped, but
Yes, ma'am.
not buried necessarily.
Well, you'd probably want them about 2 feet because I don't want to run over cars and tractors and cattle and everything else because it's going to break them up. So
You best just cut them off below ground, point them, and then cover them up. It's the laterals.
Are those access laterals?
They're laterals.
Yes.
They're like used to
Yes.
be, they're
They're for future lots.
And
For
we need to
future
protect
lots.
it for
I'm
us.
still having trouble that we just closed on this Winfield pump station
Well, thank you.
in the last few months, and we don't have access to the thing?
Don't know, I don't know that I've ever seen the closing documents. I know that I have, they were
What?
prepared by the attorney and they were
We
signed.
would not assume
You
that
weren't
we
aware of
didn't have to get the
Well,
property.
I've seen the plat, but I've never been involved in the closing in any way.
And Mr. Larson, you're saying that there is no water run to the lift station?
that is correct.
There is a water spigot
Yes, sir.
sitting there?
Yes, sir.
With no water to it?
And the water line actually runs outside the fence and then it runs up, 15, 20 feet sticking in the air. So it runs out and then it runs straight up.
Water system in subdivision, because you do have to have water at the station.
And where would be the proper place to run that water from to get to that point?
But it's not about proper. If you would put up the other drawing that I did that shows where the water line is, it's in the book. Not that. Go for the other one. One more page. Here we go.
Well, I believe the presumption would be if these are our easements and this is how we're accessing the site, we have easements all the way to the station. That would be the access. I think the legal question is just whether or not we, because it's shown on the plat.
But the sewer is on, the sewer is where in the water?
The green lines that are shown on that. It's in your book.
The green line is water?
The green lines are sewer. The yellow wheel spoke-looking things are gravity sewer manholes. The blue line out at Highway 30 is the water line. That shows up terribly, but on the screen, I apologize, but you guys have it in your book. But yes, the gravity sewer line runs down through the property as shown there. with the yellow dots on it, and the blue line out at Highway 30 is the existing water line, right?
And ideally, Mr. Larson, where are you wanting to place your house? We got a laser pointer.
It's on
Right.
there too.
It's
Here,
there.
Craig.
A little bit south,
Um,
kind of here.
I'm sorry, I'm trying to,
I
yeah.
gotta get this
I'm
on
upside
my
down
glass.
backwards.
Right in here, this is Cindy right here. Looking kind of like down this road into this
I
open
don't
area.
see it.
No, it's not. It's supposed to say it's on
Is there, are we planning to run over to our pump station? I mean,
Yes.
we don't.
What we need to
have a
do,
motor
at a discounted rate, which. What we need to do is, we need to get water to that lift station. We need to work out an easement and access that's reasonable, that covers access to the lift station for the county.
And let him
Along
pay
with
it
the
on
storm
where
drain.
we're running it.
We'll run the water to the lift station, and then we can connect the water and sewer. That's your best option. That suits everything.
You have
Yeah,
time.
what I'd like to do though is I'd like to, in the meantime, I'll plug into the sewer, you figure out the $30 a month bill, and I put in a well. Cause I gotta get it, I need to get in there. And
You're interested in putting in a well, a temporary well, while the water lines ran, and then you tie into the water line later?
we can always work that out later. But it's gotta be somewhat reasonable, that's what I'm running into, is it's hard, I'm having a hard time, keeping the cost somewhat reasonable.
So now the county's
how much
money
I would suggest that the board, and somebody correct me, I would say that we need to clean this all up. It's just a mess. So I would suggest that if you're willing to put in a temporary well that you can use for irrigation or whatever later, tie into the county sewer, we'll run the water line to the lift station with your cooperation in working out easements and such as that. And when the water line is there, then you'll connect into the water line and we'll waive the fees, the connections. Reasonable?
I can make that work.
How long is it gonna take whether to,
It's gonna take a little while, unless we run it ourselves, we have to public. Yeah,
But it's a simple job, 6 months time.
it's not over $100,000, so we didn't have to do 30, but we still need to bid it for our own purchasing policy. And then it'll have to come back to the board, we'll have to get started, it'll take, 30 days to do it. It'll take 60, 90 days minimum to get the water line in. And then as far as the easements, some of them are simple because we already have a plat we can refer to. Some of them, like these ponds, I'm not keeping anything upside down, the ones that are up in this area, there's nothing show, we like to have a plat to create all of them, so it's gonna take a little bit of time.
I would also waive the sewer tax as well, because he owns the sewer.
Somebody like Division 2 is going there.
I
to
would waive
work
the
that out.
connection fees.
Actually,
how desperately do we need water right now?
Well, for clarification, that's what I was going to
It's
ask.
supposed to be there.
Well, I know, but I mean, how desperate, it's been operating now, it's,
I was wanting to ask for
Probably
clarification, because we're talking about spending $100,000 now. Is the reason
For
because
one house.
that it would not be for one house, and that's why I want clarification, because I definitely don't want that in the newspaper, we're gonna spend $100,000 for one house.
How would we spend 100,000 when he's projecting 9 or 10?
It's to service the subdivision, the pump, because the pump station's supposed to have it service the entire subdivision that's already there.
No, it's just for a hose bill. The 2-inch water line, we don't have to run in a 6-inch line or anything like that. It just has to have a hose bill by EPD rules, which is a 3/4. A 2-inch line would be adequate.
So we don't have to spend $100,000.
No.
Well, I don't know where that came from somewhere, so, okay,
It would not be 100,000.
okay.
I'm sorry, Public Works Construction Law says over 100,000, we have to bid per Public Works Construction Law. What I meant, it would not exceed 100,000, therefore we wouldn't have to follow those requirements, but we would have to follow our own internal purchasing policies is what I meant.
And I'd be a little concerned with running 3,000 feet of, 3 or 4,000, it's almost 4,000 feet of line out there, of 2-inch water line.
2-inch line is going to supply a lot of water. And pressure is pressure.
Well, but you lose a lot of line
Pressure
pressure.
size.
You lose a lot of line pressure in
It's
route.
volume, not pressure. You get pressure on a 4-inch line, but you'll
Yes.
lose flow.
see, me, I would allow him to put a well and septic tank in and then
Figure this out.
let him provide us water at the lift station.
I could do that too. That would also be an option, because I could run the water all the way out to the lift station.
Right.
That would make sense.
Whatever y'all.
That would be a solution.
But then you need some kind of agreement to sort of halfway work with. Somebody reads it here, so halfway. You know, we need to have something that's not complicated. What we need to do is solve all these other issues with
a 2-inch line that distance. Then you'll be able to get your volume and your pressure, keep it up.
Okay, I mean, you know,
Because the 2-inch line's only gonna go to you as far as the house, and because
Yes.
the one at the lift station's not, it's just gonna be a hose bib for washing out. If a pump has to be put in, you have to wash down the pump, so. So it'd be right back to the 2-inch line that you have proposed already, as far as you're concerned.
right.
So for clarification of motion,
Mr. Mason, would you like to turn that statement into a motion for the record?
I'll make sure, let's go over, we're gonna allow him to put in a private well.
I think before we get too bogged down in all this, what's before the board right now is whether we're going to require him at this time to connect to the water and
Yes.
sewer.
And that answer is yes.
Yes.
And that is,
Well, is that what the board said? That's
is that what the board is saying?
With a 6-month delay or a reasonable time on the water. Long enough for us to get a contract bid and awarded and built on the water.
We have not taken a vote on that part, but that's the
That, I mean,
way
that's
the
what
motion
the motion
is
was
moving.
not.
Well, that sounds like the best for everybody.
I want to make sure we're clear, I did not ask that. Look, so you are going to tap into Ward City.
County
I want
water.
to get confused now. County water and sewage. We're going to waive the fees. Correct?
I think best is you make the motion.
I'm trying to work through it, because I'm trying to understand it myself. Allow him to put in a private well, and once we have water available, then he'll connect to that.
Water available to the pump station.
Or reasonably available, which would be the pump station, it would be reasonably available.
And you can connect anywhere along the line.
But you would go
And
ahead
that's-
and
and that's all
tie
part
into
of-
the septic.
We need to make sure it stays reasonably available, and I think
Yeah.
the money is.
Well, like I said, if it was at the station, if it was there. So anywhere
That
along
would
the
make it
line.
easier.
Yeah, that's reasonable. And then,
I still think that the ordinance probably needs to be relooked at all, because it's still, you know, and I'm not really sure that back when they designed it, it was designed for 80-acre properties or 1,000 acres or whatever it would be. So probably a better definition of reasonably available.
And the board can, we can look at the ordinance completely separately, and that can be brought up at another meeting. But for the time being, we are going to require him to connect to the water and sewer. Now, you just need to determine whether you're going to require him to connect immediately, you're going to give him 6 months. And in the meantime, is he going to put in a septic tank? If that's,
You know, put in a well, connecting a septic tank. Put a well in, then when we get the water running in 6 to 9 months, then he would tie it down water, is that right?
And Mr. Larson's number that you threw out a while ago was he would go ahead and connect to sewer.
Yes.
He would pay a $30 per month fee was the number he threw out for usage of the sewage until such time as he connects to the county's water line and it is metered.
Can we legally assess
can we set a flat
one
rate?
fee for one person?
I don't know.
Sewer fee?
I'm just telling y'all what's been thrown out there.
that's not in,
That won't meet
No.
at all.
no.
Still, he's totally tied, I wouldn't say we charge anything, because he still uses his own line.
Can't do that. Can't do
Until
that.
he's actually tied in, I think it, rather than, assigning some arbitrary number to what the fee would be or should be, I think the board can simply just waive the fees until he's fully connected.
Yeah, I would agree with that.
Fine.
I would agree with
Yeah.
that. And rather-
All I was doing was, Forrest was asking what all's out there and I was just trying to.
That would give us some sewage at no monthly cost for a while until we have the water line. And I wouldn't say you have to put the 6 to 9 months in there, because it's up to us. If we can do it in 3 months, it's good. We can do it in 12 months. Whenever we do it, whenever it's available, he has to tie in. Within 30 days of us.
There you go. In the
completion.
motion, make it within 30 days of notification that it's about.
Yeah.
I should be able to see you. Looking right out the window.
Yeah. Just gotta have some.
You got all that?
And,
Trying.
and 6 months of $30 a month fee is not enough to go out.
No.
The
Well,
motion
and
be,
y'all's ordinance doesn't
We
allow
all fees
separate.
until he
Waive
waves
it.
everything.
that's what I'm saying, allow allow for a private well, waive all fees, including tap, whenever we get the service there. And then once we have it available, then you would start, you tie in and start being billed, and then we give direction to staff to work on cleaning up this ordinance. These large tracts of land like this, make it not so arbitrary.
But we also, in this motion, we, you know, that we're going to, because he's offered to work with us on getting all the legal stuff squared away. All the easements and
Right.
the ownership of the pipe, all that stuff, and let's get that cleaned up in all.
Should we legally put that in the motion as far as, does it sound like we're, I think we have to be careful about making a requirement, but I think we can certainly state here tonight that he's willing to do that, but should that be part of our motion?
No.
Okay, because it's almost like extortion.
And quite honestly, that might already be handled. I don't have the closing documents in front of me. I didn't draw it up.
Well, but
My
it's
feeling is that
the
probably.
issues that Toss brought up,
Right.
the drainage across property, all those such things, that's the stuff I'm talking
Ms.
about.
Larson is agreeing to work with the county to correct any deficits which may exist in the easement of the water and sewer.
I still don't think that should be part of the motion, because that's not what he's here to ask for.
Maybe that's not correct. He says it, or that's the thing.
But that's your understanding.
Yeah, I'm here to work with you. Just so you kind of get an idea of what we're talking through here, I went through Tommy Lee Construction. I don't know if you're familiar with them out of Savannah, and that's what they do. This is what they do. They do sewer and they do storms drains.
Terry Lee?
Tommy Lee. Is Bobby Lee, I believe, is his son. He's the chief engineer. That's who I talked to over there. That's the way I understood is Tommy Lee. But Bobby Lee is who I talked to, chief engineer over there. Bids their projects. In my kind of math, the sanitary sewer lines are about 4,428 feet. The approximate is $25 a foot to lay that. The manholes are somewhere around $3,000 a manhole, and you're looking at 21 of them by the plat. And that's, I don't know how many are exactly there because they're not all sticking above the ground, but that plat shows 21 on a sanitary sewer. You're looking at another $173,700. The storm sewer, you're looking at 4,100 feet. That's 48-inch sewer too. 36 runs about $60 a foot, probably about the same thing for 48-inch. And that's just the buried pipes. $246,000. 3 to 5 manholes at $3,000 a piece. And that pond in there, and the other trenches that for the water to run through, and looks at over $300,000. So you're looking at $500,000 worth of work in there right now. I will say that I did buy that as an investment property, as I said earlier, and I paid too much for it. So working with the county doesn't mean giving it to you for free. Because I'm not sure you would really desire, I mean, you're not gonna let me live on a sewer for free. You know, although it is my sewer, I think, that I'm tapping into. My belief is that I own all that. And there are no easements on there. What I'm saying, I'm willing to work with you, is I'm willing to work to make sure that when we turn around to make this a subdivision someday, whether it's me or my kids that sell it to somebody to do it, that it should be easy to convert and not a whole bunch more, you know, not a whole bunch more of, well, this easement's now 30 feet, but we really needed 80, or we don't want this to happen, or this is already done. It's already done. You've already taken it, you got it, you got the easements that you need to correctly fill what you got. But I want to be careful in the fact that I'm not necessarily offering this all for free, but I want to work with you to make this thing happen.
Well, and to clarify on the county's part, I don't have the closing documents in front of me. I know we have the
I
plat,
don't have all the answers.
but
Correct.
we might have those easements. The county might actually own those already. So
We need to let you research that.
we need to find that out before we make any sort of motion or any sort of agreement on that.
Yeah.
We can move forward on this.
That whole thing is a mess.
We'll have to clarify, correct, and
So that's really what I brought. I didn't bring up all that other questions. And I don't, you know, like I said, I don't want to go out hiring some lawyer to try and make something happen. That's not what I'm looking for. I want to work through it.
it is what it is, whatever it is.
Whatever it is, and the issue for y'all right now is whether or not you're going to require it now. And whether that be 6 months from now or when it is available, when you get the water from the lift station, you can do that.
I'm still completely good with the way they have just hashed that out on that part.
maybe, maybe not. And my intention was to clean all that up. But I'll tell you, I have no intention of buying that water and sewer system, that storm system as the county in the future. If and when that time comes that you would be to where you could develop it in the subdivision that it was originally intended to be. Again, now you're in the position as a developer, lucky for you, you've already got everything in the ground. But the county doesn't pay for the water and storm and sewer to be put in subdivisions. We don't buy that unless it's a system improvement, and that's why this lift station was bought, because it was from other areas coming in here and being pumped and sent down the road.
Well, in truth, you changed a lot of your value when you changed your zoning.
Correct.
And so, you know, if you need to get rezoning again for those things to work, that's something that's a strength that the county will have in that negotiating.
If we own that, if we own that, it has to be a system.
You bought the
If
property.
sewage coming in there,
Heritage Bank.
it's a system improvement.
Farmer's Merchant.
It would be
Savannah.
smart for you to maintain it so that it can be used in the future. That would be a smart thing.
Correct.
But as far as us paying more for it again, I don't believe that would happen. And get the zoning back where you need it, you know.
See, I think that line is
Steve, is-
developed as a project improvement until he ties in, the day he
Is
ties
this,
in.
is that lift station pumping sewage?
System improvements.
Because it has a line coming to it from other places, right? Right.
Wow.
Okay. From other.
Because if not, we wouldn't have bought it. Because we needed to keep it online for the other projects that was done, that's why it's bought.
But see, this is another one of those things just that ties into, we've had a list of properties that we want to be sure we get, if we don't have title, we get it straight. And we need to do it. This is an example of just how important that is.
I think the model is fine. I think the model is good. Go through.
Your motion.
Is that right, Steve?
State your
Wait a
motion.
minute, I had a motion, I thought.
Well, he did, you did, which one you?
No, I never made a motion.
Okay, well, go ahead.
The motion was to allow a private well whenever we do have water available, if we tap into the county water. He would go ahead and tap into the county sewer, all tap fees, and all fees with water sewer will be waived. Until he does tie into both water and sewer.
And he would do it within 30 days of us making him aware that it's available.
Right. Or is this issue?
Yes.
That's fine.
Yes.
Is that good?
You good with the way that's working?
I'm fine with that.
Second.
Motion and a second. All in favor? Any opposed? Let the record show Mr. Mason voted no. Thank you, Mr. Larson.
Thanks, sir.
We look forward to working with you.
Me too.
We'd like to have lots there, more customers.
I like you to come out and visit. It's nice.
All right. Next item. Consideration to approve and execute a policy for catastrophic inmate medical insurance.
Good evening, Fiona Charlton, purchasing agent. On September 10th, 2013, the board approved a bid from Public Risk Underwriters for catastrophic inmate medical insurance, which covers catastrophic medical expenses on jail inmates who are not under state custody. The policy documents have been received from Public Risk Underwriters and they comply with the accepted bid. The documents have been reviewed and approved by the county attorney. The premium is $13,541 with a $35,000 deductible and a $250,000 limit of coverage per inmate. The plan period is October 1st, 2013 through September 30th, 2014, with 12 months incurred, 18 months paid. Staff recommends alternative number 1 to approve and execute the renewal policy with Public Risk Underwriters.
And the funding for this is included in our current budget.
Yes, sir.
Any questions? Motion?
Motion we approve staff recommendation.
Motion and a second. All in favor? Any opposed? So carried.
Thank you.
Next item, consideration to approve job description for Department 61 and 105.
Good evening, Russia Zinsky, Human Resources Director. We're seeking approval from the board for the following job descriptions to update for realignment for departments, of course, 61 and 105, which is your wastewater and water sewer. We're looking at water utilities operator, water utilities lead operator, and water utilities project specialist. When we designed these originally, and then again relooked at them in 2009, the department has evolved and it needs some different job tasks listed, and this is what these new job descriptions do. We'll be changing wastewater supervisor to water utilities lead operator, wastewater operator to water utilities operator, and we're going to add in water utilities project specialist. We are not going to increase any funds or change pay grades on these positions. This is a title and job task change only at this time, and we're asking for approval for the job descriptions for Department 61 and 105.
Any questions?
Can I just make a little request that in the future, whatever changes are, that's either highlighted in red or blue or something so we can see what the actual changes are?
They're almost all completely new with job tasks, so, but I can give you the old ones if you'd like to compare. Absolutely.
I didn't know how to see what the actual changes were.
Sure.
Any questions? Motion?
Make a motion to approve alternate number 1.
Second.
Motion and a second. All in favor? Any opposed? So carried. Next item. Discussion of board policy, modifications and financial policy updates. And before we get into that, we're going to take a 10-minute break. So, all right, let's get started again. Item number 5, discussion of board policy modifications and financial policy updates. Does not tell me who's going to present this.
I think it's a little bit of a collaborative with all of us.
All right?
Please turn the mic so we can hear.
Hold the mic. Thank you. Yes, ma'am.
I still don't hear.
Yeah, they want to hear you.
Ready when you are, whoever.
As we have noted in the past, we have gone through and tried to make a correlation of all of our current financially based policies. The document that you have before you, I believe, basically goes through and outlines both our current policies and also to those additions to those policies. And what we're going to try to do is go through and walk through with you each one of those policies. They've been pulled into different sections and aligned with both current and former policies to try and ensure that we have a cohesive document. Also, one of the things that we really look at here is that effective policies and procedures help staff to carry out their daily operations. And it provides the elected officials with the ability to direct and guide us as staff in our duties and to allow our citizens to understand how their government works. With that in mind, we also know that businesses need policies for dealing with what is an inevitable collision of a worker's beliefs and their personal and professional duties. Our goals in doing this and updating financial policies in the framework is to provide accountability and transparency, to promote strong internal controls, dual systems, to ensure that we're in legal compliance with the use of our funds, to establish a real framework for our financial operations without limiting management's discretions or independence, to improve compliance with GAAP and GASB, and to have the ability to have accurate financial information on a timely basis. To help us comply with the vast financial regulations, and we're fixing to go through those now. I'm not sure that everybody understands how many regulations that we're under. Right now, we're under, of course, the Board of Commissioners' current policies. We basically look at the GFA, which is the Government Finance Officers Association, and their best practices. We're heavily regulated by GAAP, which is Generally Accepted Accounting Principles, by Generally Accepting Auditing Standards. We're heavily regulated by General Accounting Standards Board, which is GASB, the Georgia Department of Audits, the Georgia Department of Communities Affairs, and the GOA, which is the Government Accountability Office. They have had two major revisions of what they termed the Yellow Book, one in 2007 and one in 2011. And that has been the crux of some of the changes that we've made in our accounting system. We've also looked at the state as far as their accounting procedures and what they dictate. We currently have in excess of 29 funds that we service. We have in excess of 65 departments and agencies, over 2,000 vendors at any given time, 35 bank accounts, and 10 to 20 grant programs that we administer. We have an annual budget of anywhere from $75 to $100 million per year. And we have our monthly financial statement updates. Those are just some of the major pieces we service. In addition to that, some of the things that some people don't realize that we do is we have our excise tax that we now administer, our hotel motel tax that we administer. We have jury checks, recreation official checks, mileage checks for our senior meals. We have to bill out our OmniFlight fuel in our municipalities for fuel. We have over 1,200 water and sewer customers to service. We basically do all of our service delivery as far as administrating that, our vendor payables, lease payments, bond financings, and grants. Every single dollar that we take in or expend is tied to a mandated reporting in some manner. The DCA annual report is a line item report that we are required to do by the state. We have victim witness reporting, annual audited financial statements, the Georgia Transparency Act, which basically means that we have to update information with the Carl Vinson Institute. We have an 89-page checklist for the Georgia Department of Audits that we have to go through. We have our annual sales tax report that's mandated by the state, salary and wage reporting, and of course the government Office of Budget and Management with our A133 compliance. All of these are major reporting items that govern how we do business. Also heavily regulated is our federal and state grants. Our ARA funding is heavily regulated. Monthly senior meals is heavily regulated. Our quarterly financials for Family Connections, our GEMA grants, our FEDA kit. We also now have recently had to start reporting with water consumption in GFA. Why does this framework matter? It matters because communication about expectations is the first step. Regulations are ever changing. It outlines our responsibilities and our duties. It allows us to consistently and efficiently run our operations. It provides for a consistent manner to address the financial and administrative operations. What you will see in the documents that you have are our current policies to our updated policies. We divided them into 8 areas: our accounting and reporting, our general oversight and internal controls, our asset and cash management, our fund balance, budgeting and budget amendments, capital improvement programs and our budget there, financing and debt management, and purchasing and procurement. Within our accounting and reporting, we went through and we isolated our objectives, our account and reporting systems, our revenues, and our banking. We've updated what was our 2008 financial policies to reflect our current objectives and principles in the major areas of accounting and our reporting standards. And what you will see in those documents in those first items are a correlation between our 2008 and our current update. And I'm not sure if you want to go through those pieces individually, or let's go through the entirety of it and then go back to the individual ones. That's your choice. Okay. Our general oversight and internal controls. There's our general statement, responsibilities designed for internal controls, documentation of internal controls, administration of those, review and evaluation, standards within payments or disbursements, standards of the revenue cycle, and standards within financial statements. Within this general oversight and internal controls, this portion of the policy has been updated to heavies. It's been integrated into our existing policies, and that is because of the fact of the governing regulations that we have, such as GAAP, such as the GOA, such as the Department of Audits. Why are those internal controls so important? Each organization has a responsibility to assess their internal controls and to monitor those to make sure they're suitable for the organization. One of the major reports that has dealt with some of this information is what they call the Costco report. And that was developed in 1992 following recommendations from that particular committee. Activities undertaken by management to increase the likelihood of achieving management objectives. That's what internal controls is about. It's about the effectiveness of the operation, the reliability of the financial reporting, the compliance within the laws and regulations, and safeguarding of assets. I'm not sure if everybody understands all the premises of those internal controls, but let's give a brief overview so that we have a process within our organization for achieving those objectives. There are 4 objectives basically that fall into related categories: effective and efficient operations, reliability of financial reporting, compliance with laws, and safeguarding of those assets. Several key points. People in every single level of organization affect the internal control. Internal control is everyone's responsibility. It promotes and reduces the risk of the assets and promotes the reliability of financial reporting. Internal controls, though, can only provide a reasonable, not absolute assurance regarding the achievement of our objectives and the likelihood and the limitations and the inherent protection of our assets. Top management of the organization has to assume the leadership of those internal controls in the areas of responsibility. And that's why we've asked that we have a strong, active board, and that is coupled with communications and channels where we can talk about financial and legal and internal audit functions, and we can identify and correct situations so that controls are not overridden. As I mentioned earlier, the Costco report, that comes from what they call a Statement 55 and from SAS, or Statement 78. Those are particular documents within the accounting arena that basically dictate the internal controls and the standards that we should try to have. Internal controls consist of 5 components: the control environment, a risk assessment, and that basically looks at what do we have at risk and how can we protect it. It also involves monitoring, which looks at basically whether or not our controls are operating properly. It also looks at information and communications to make sure that those communications and those lines are open so that we can make sure that we're managing those things and monitor it. And so we look at the environment, and we look at what's affecting those things, and the administration and the monitoring of those things. And all of those things are important to ensure that that controlled environment is there. Under the general oversight of internal controls, this portion of it has been updated to integrate with the existing policies. And we've used the background of all of those organizations that we've talked about earlier. We've used the background of GAP, we've used the background of the General Finance Office best practices, we've used the background of the GOA, we've used the background of all of those scenarios that govern what we do. The activities of the control are in 3 broad groups. Preventive, which says, how can we best avoid this? We also use detection. And that means our reconciliations, things that alert us that there's something wrong. We use corrective controls. And those are controls that once we realize there's something that is amiss there, or is something that perhaps needs to be looked at more, that we put those controls in place and we mitigate those issues and mitigate that risk. The next piece that we updated was asset and cash management. That included the general statement, currency and coins, checks, deposits, controls over assigned duties, theft of funds and assets, and segregation of duties. These are the two. Number 2, 1, 2, and 3 are the ones that we updated the heaviest. On the assets of the cash management, we basically went back and looked at what our existing documents were and upgraded those within our existing policies. We looked at our fund balance. The fund balance policy that we have right now, the purpose, the definitions, the committed fund balance, the assigned fund balance, the spending order, and the committed stabilization. We went through and looked at those pieces, and for the most part, that fund balance was initiated back in 2011, and we did not make any changes within that particular piece of the policies. Again, it was updated in 2011. We did so at that point because we had to comply with what is termed the ASB 54 pronouncement, which mandated the structure of the changes in the definitions, and at that time we put that policy in. As far as budgeting amendments, some of this information currently comes from the 2008 policies, along with our current resolutions that we are using within our budget amendment. And those two pieces were correlated and pulled together to give you the current policy update. Capital improvements program and budget basically remain the same, though there needs to be some updates to it. The version that you have currently is the version that is in place at this point. As far as financing and debt management, if you recall earlier this last year in 2012, we had to, because of our certificates of participation, adopt a resolution. That resolution basically was to ensure that the oversight of those particular financing venues and this particular document has remained basically the same. Within purchasing and procurement, we basically made some changes, and those changes were relative to the corrective action plan. And within those, we basically changed, if you can go to the next slide, the routing of the mail, related party transactions, and gave definitions in there, process as far as the check date, the approval authorities, and the acquisition of services, were the items touched within that language. Within the grant applications, for the most part stayed the same, except to update the policy and the language that had to do with those items for the corrective action plan. The last items on here have to do with how this all intertwines to our corrective action plan. And what you will see is that we did a chart with the corrective action reference number on it, the actual policy reference. You will see that it shows the letter or the item that particular language is within, and then number that it's within. And then you will see it by page number. We did so to ensure that as you were going through this particular document, that you could pick out those pieces to ensure that we were addressing those items that we noted that we would address within our corrective action plan. And so, for instance, on the 2012 correction action plan for number 1 and 2, if you go to your actual policy procedure document on page 1, under B1, you will see that, for instance, there is notification of non-compliance will be made by written communication to the Board of Commissioners in a timely manner. And you are also provided, I believe, with a current copy of the actual financial policies. If you would like, we can take that and go through the current policies and show you where those current policies were either merged or moved into the actual document itself. Or we can go through and, once you've had a chance to review this, answer any questions that you may have, or have direction for the staff at this point.
I got a couple of questions. On page 46 of 70, it says page 3, but it's page 46 of 70. Apparently there's 7 pages in the total one. 70 pages.
This particular draft is showing there's 20, I believe 25 pages.
When they
The
put
agenda
it,
book?
when they put everything together, Joanne, they
Page 3.
made it 70 pages. I mean, it continuous.
Okay, thank you, sir.
Under general oversight and internal controls, which is under accounting and reporting, and then general oversight.
Did you say 47?
Yeah, page 46 of 70.
46 to 70.
Which,
CDE.
C. Well, this is design and documentation.
Okay, I've got page 46 and 70. Yes,
Okay,
sir.
under C, design, documentation, and internal controls, the strike through of the first section, finance director, director responsible, why is all that struck through? In particular, the finance director is to inform and report to the administrator and board of commissioners regarding internal controls and place and functioning of them. Why is all that struck through?
When we as staff went back through this, what we realized was that some of the items that had been copied into this were copied into this several times. And in working with Adam and Toss, they felt like that particular item could be struck simply because of the fact that the language in it wasn't necessary. The language down below, such systems of internal controls, was adequate.
It's pretty much covered under 2A if you back up a section, Mr. Mason. Under general oversight and internal controls, general statement, an adequate system of internal controls is necessary. The administrator and the finance director have responsibility to create a system of internal controls. It was sort of covered there. It had already been stated basically.
Okay, so it's struck because it's stated somewhere else.
Yes, sir. Yes, sir.
Basically, the strike through is like, Joanne, if I understand correctly, you wrote the policy and then presented it, and the strike throughs were done after. Is that right?
We had already given this to the board. previously just a half. So the strike-throughs are different from the copy that the board had previously been given.
We'd have to talk
So-
about it.
So down in E, section E, right below it, CDE, finance director, again, is on direction of board commissioner administrator. So you're saying that's covered up in the
Yes,
same situation?
Too much redundancy.
exactly.
And I guess the reason for this today, y'all wanna go ahead with this, right?
We want to discuss it, yes, sir, and to back up a step, we took a bunch of different policies that were in existence, plus some additional ones, and sort of merged them all together. And in doing so, as we went back through them, there were duplications, there were redundancies, and there were things that we as staff felt needed to come out, which again is to strike through. The previous version that had been given to the board was really after everything had been merged and formatted, that's about it. We had a lot of time going through and looking through the document to get rid of circular references, to get rid of those things. That's what the second draft is to try to remove the redundancies and so forth.
A lot of it
And
cut
the
and
reason,
paste.
and the reason I asked that, I know we're not gonna vote on this is just for discussion.
Yes, sir.
But I myself, I need more time to look and read all this. There's 70 pages of it.
Understood.
And I don't know about anybody else, but I need more time to read it and understand
Well,
what is going in this document.
Rich, I believe it's so that they can get any comments or questions we have.
Well,
Yes, sir, that's why it's a discussion, so we could go through it, get your concerns and responses, and put them in the documents on before it comes up for a vote.
Yeah, it's listed as discussion, and another thing to note about the 70 pages is, it's the old and the new together, so the new documents have that.
Okay, so my last question.
And I understood that, but I don't want to go ahead and say,
Yeah,
well,
we're talking about
we got
merging.
okay to go forward with this, and I know we wasn't voting on it, just for discussion.
Yes,
But
sir.
I'm saying just for myself, I want some more time for me to read this and understand it, and I might have some more questions, and you
Yes.
can ask a couple of them.
Okay, page 65 of 70, which is approval authorities, alphabet letter Q. This is page 22 and then page 65 of 70.
Yeah, number 5, that's your question.
Yeah,
The reason for that is as we went through this, that's the existing policy. Discussions internally is, I can't recall when we've ever had the board actually do that. So we have been violating our own policy for some amount of time. Now, obviously, if the board would like to leave that in there, we can certainly do it. But this also, if you go up to the top, applies to budget.
Number 5.
4 and 5.
Yeah.
4, expenditures of 10,000 and over, of 10,000
Yes.
and over may be authorized by department head with approval of the finance director, administrator.
Yes, sir. And if you go up to Q, you'll read that this whole section applies to budgeted expenditures. So these are only expenditures that the board has already approved in the budget. So the board knows of these purchases, it's just not coming back to the board and asking for approval of the actual PA. There's another section for, non-budgeted expenses, the new number 5, non-budgeted requiring approval of the board prior to purchase. So any non-budgeted expense requires the board approval. That section is only budgeted expenses.
And
Just make the budgeting process.
Yeah, like progress payments on
And the
a,
reason why we went through that sequence, and that's been about 3 years ago now, when we actually made this change in that language, was because we had capital items that necessarily were in the budget. And we wanted to see whether or not we actually needed to spend them, whether or not we had the money for them, and so forth. And so that's why there's a series of, it's not just the department head going out and spending those funds, but if it's over $10,000, we're checking to see that those funds actually are there and available.
Well, my question is on that, or my comment on that is, you know, there may be times when we budget for something in one year, and then something comes up through the year, and we may not need to do that later. So what we're saying here is, if we budgeted for it, we're gonna spend it. It's not, anything over $10,000, up to any amount, if it was budgeted,
But
It
it
can
said
be
automatically
spent by-
suspended, just
No, I think what this refers to, Commissioner Mason, is take a pay request for Old Augusta Road that comes in, it's $160,000. Under this, it requires the board's signature prior to approving that payment request, because that single expense is over $40,000. Even though it's budgeted, even though the board approved that contract, that one payment is in excess of $40,000. So we would then have to bring those pay requests to the board. Doesn't necessarily have to be in a meeting, you know, maybe the chairman can sign it, but, and again, we could certainly leave it there. It was just, I believe that we felt that the intent was that the board had already seen the expenditure because it was budgeted. So it just didn't require a comeback. That's the only reason.
But there are certainly times right now that something that's budgeted doesn't get spent, so it's not automatic that we're definitely gonna spend it, it just gives you the ability to do it because we've already approved it.
Exactly.
But that's kind of what it says. It says, if it's a budgeted fund for supply services and capital goods, anything over $10,000, as long as those staff people, it can be done.
Can be, but not.
Maybe.
You want to have to do every vote on
That's what I'm
everything
saying.
that's spent, on every
I think there should be a dollar amount, a threshold. I mean, because
I think what Paulson and them were looking at when we were discussing this is exactly what he talked about, which was on the contracts. And I think at one point, somewhere in this last year, it got left out that contracts, as long as the board had already approved the contracts, that those contracts could be signed off on by the individual project manager overseeing those, along with the administrator. And in this particular case, I don't think there's anything, I mean, we can limit it to 10,000 or under, and certainly do the exact same thing, and pull the language the other way.
it said, all right, it's been struck through, it's in blue, but it's been struck through. Expenditures of $10,000, up to $40,000, which is struck through, may be authorized by department head and so on. But now that's been struck through and it says expenditures of $10,000 and over may be authorized by department head and staff.
Correct.
So it's not given a top amount, is what you're
Yeah,
saying.
there's not a top amount.
Correct.
It's
Just
not
anything over
limited.
10,000, you're right.
Yeah, so it could be,
There needs to be a
whatever.
limit, there needs to be a limit.
Yeah. And again, the thought was it was already budgeted. I understand your concern, and certainly that's why we're having this discussion. If you're not comfortable with it, we can move the
I
strike.
think we need to put a
Cap.
number in, yeah.
Yeah.
Okay.
Joanna, may I
Yes.
ask, where in here does it authorize me to sign those pay requests for the jail?
In the past, and that's what I just mentioned about the contracts, there used to be some language, and forgive us, but in 70 pages of documents, we're also looking through, and I can tell you, going through weeks of looking through, once we merged it, we're still, there's things that I've made notes of, that I would like changed, but, in the past, as long as the board had approved that contract, then the chairman had the ability to sign for that particular item.
And are you saying that was just because it was a standard operating procedure, or there was a policy somewhere, because I think that's what he was asking?
It's not only a standard operating procedure, but in the past, if I'm not mistaken, within the language here, there was the ability for whoever was overseeing that project management to sign off on it with no further approval from the board,
And
except for
actually,
your signature.
that was a resolution, if I'm not mistaken, that was passed by the board that allowed for those pay requests, am I
Yeah.
correct?
Yes, sir, if I'm not mistaken.
So where is it covered in this scenario?
In this scenario, I don't know that it is, sir.
That's what I'm saying. So in that case, it would be coming back to this board
Each
to
time.
authorize me each time. It's not, it wouldn't be good enough for you and Adam and or whatever to look through the numbers to be sure. Even though it's bonded, even though all the other, it would have to come back to this board to authorize me to sign it.
We need to reference a resolution like that. Do we have a way to reference it so that we can?
If you
pull
look
it up?
if you look in section K, it is somewhat identified in here, but I think we do need to clarify the language. It says expenditures approved by the Board of Commissioners. Purchase orders or invoices for expenditures approved by the Board of Commissioners shall be accompanied by a copy of the minutes reflecting the board's actions and contract, if any. which together shall serve as authorization of the expenditure. Funds may be dispersed upon approval of the project manager or department head overseeing the expenditure. Request for payment of the budget funds must comply with the procedures outlined by the Board of Commissioners and/or county administrator. I think somewhere in this language, there was language that basically said that,
All right. But if it says procedures, and then you're altering those procedures back up in here, it would be a conflict. Right?
yes, sir, we need to clarify that language.
Joanna,
And the language Mr. Mason referred to.
is there a way for us to reference or find a resolution quickly when we want to reference something like that? Because the other day I was trying to figure out if there was a way to do that online, and that's why I was wondering about the resolution book, that you just have to search through that by date randomly. But if you want to find a resolution on that subject, is there a way to find that easily?
Well, it's not online, but there are digital files that have been put together by year of resolutions.
They have to search it by year, like a resolution that was made that year.
For every bank statement, bank account, all of those resolutions.
We need some way to tie it to where you can type in a search field and find what you're looking for.
You know, we've got record management piece in the short-term work program we were referring to. That allows us to begin to do things like that.
It'd be good to have a resolution set.
Okay.
So what I'm hearing the board say is that we need to clarify language in K, and we also need to set a cap, and certainly we can leave number 5 in there just as it is. Unless the board would like to lower that at all.
Yeah, I mean, 40,000 would do it. I mean, we can leave it like it is unless we would like to set some other.
Well, I think what Commissioner Mason's saying, I kind of agree. If we budget $200,000 for a new fire truck in the budget, when you go into the budget, it's easy for, something to not really get noticed, and then we'd like to have about $200,000.
That was one of the reasons why, we had put the number 3 in here, that expenditures over $10,000, basically, I did see those. And the reason why was to look and see whether or not we had those funds. Because what we had happening at that time when this language was written was we had different departments, going out and saying, well, I've got $25,000 in my budget, and so I can go ahead and order that car, or I can go ahead and do this work, or I can go ahead and do whatever. And so we put that limitation in there so that they had to come through, finance and administration to make sure that the funding was there. And correct.
I agree with the cap being necessary, but I thought I heard a statement about we struck one thing because we've been breaking that anyway.
Well, again, the way I saw it when we were going through striking, and just like the fire truck keeper, we really can't buy that by the contract anyhow, so the contract has to come to the board to authorize that purchase. Now, is there a scenario in which we could spend the $200,000? Quite possibly. I'm sure we could find one. So, I certainly understand the board's concern, and I have absolutely no problem with any spending limits. The way we viewed it was that the board had to approve a contract, such as our progress payments. It was a contract that was approved. That's what we were looking at. Again, I'm not trying to be argumentative. If the board wants a cap, I certainly have no qualms about whatsoever.
But I'm trying to understand what we're breaking.
Toss was thinking that because of the fact that we were not getting necessarily a signature from a board member, okay, that we, in fact, kind of were breaking our own policy. But I believe that K, which is the item that I was talking about, page 20,
Okay.
is what we were using to say that once the board has approved a particular project, okay, whether it be Old Augusta Road or whether or not it be the current jail piece of it, then we had the authority, as long as we were acting within that contract and what you had approved, to go ahead and make those progress payments.
I would agree within a contract board.
And that was my fault. Old Augusta Road is an example. I can assure you that I signed pay requests in excess of $40,000, and I did not come and ask anyone on the board to sign that. So my thought in looking at this was, look, I violated this policy. So, and it may very well be the case covers it because it was an approved contract on the board. But that's what we need to clarify. When you get the cap back in here and make sure that.
We just need to clarify that language, I believe.
Yeah.
K was intended to cover that.
63.
I'm on page 20 of the document.
We just took K out,
Did you?
just chairman.
I got you.
Page 20 of the
And
document.
see, y'all referred to page 20, and I was looking at 20 of 70. and
Yeah.
63 of 7.
I got it.
63 of 7.
Yes, sir. Again, these were, you know, we went through and tried to pull all the current documents that we knew of and assimilate those into this particular document where it was cohesive. Where, you know, all the budget pieces were together, where all the purchasing pieces were together, where, you know, all the financing pieces were together.
All right. Is there a timeline that you would like us to look through this, review it, and come up with any other questions or changes that we might offer so that we can get this finalized?
The 120 days that was in the corrective action plan, I believe gets us towards the end of October. So we can get this by the second meeting in October, I would appreciate that.
Well, we had our first set at the last meeting, and then we got this second set at this meeting with the revisions, and it's just a strike through, so this is the second time it's seen.
If the board would like to come back at the first meeting in October and provide any additional questions or input, that would allow us to put it together between then and the second meeting in October, we actually voted on.
And some of the things that we didn't go over tonight, I'm sure you all noticed that prior to the financial policy changes is our procedural changes.
And I would like to discuss that with y'all real quick tonight.
Okay, I wondered about that because there's some.
Yes, ma'am. We just went straight into finance. In addition, there's a travel policy update that has already been written that will be, we can do it however y'all want. We can put it back on the agenda for discussion at the first meeting in October along with the financial policies, so we can go over any additional questions. Or we can just hand it to you and vote on that at the second meeting in October. It again is the same thing. We sought to take the two separate policies. There was a policy that applied to commissioners, there was a policy that applied to staff, and merge those two together in one document that accomplishes the same thing. But largely, it's just a merge of those two. And when we actually get to voting on this at the second meeting, there's several that I can go over in a moment. That again, I'm going to ask y'all to appeal, which is all the ones that we have combined. Plus, there's some road construction policies that we're clearly not abiding by. There's an ash policy that I would very much appreciate if y'all get rid of. You know, and all the other ones that we combine. And then after all of these individual pieces are approved, we're going to go back and take the SOP and revise it, standards of practice, the human resources policy, because it refers to a lot of these documents. So once we have clarification on where those go, we'll take that SOP and pull it all together and do a update of it also.
Now, what were you saying you wanted to add at the next meeting?
There's a travel policy, yes, ma'am, which has already been prepared. It's already done. It's just, we can do it however we all like. If we want to just give you a copy of it, we don't necessarily have to discuss it.
How many pages is it?
5 or 6.
Sure.
It's not very long, 3 to 6. Yeah. And again, it's largely what we have now. We've made some adjustments to it. They're all in strike through. Everything from existing policy is strike through, mainly with the exception of the board's travel policy, because much of it mimicked the other one. There's one segment out of it that just says the board requires prior approval to approve your own travel. That's really all that's left of it. Everything else was a duplication of the other.
Something you can email to us so that
Yes, ma'am.
we could review it and have it prior to the.
Yes, ma'am. I'd be glad to do so, and then y'all can continue to generate comments on this financial policy as well as the board policy that we'll go over in a moment.
And if you want, I do have it set and marked up of where these items are merged. So if you're looking at your original document and you can't find it, or you think something's changed, or you're wondering about something, let us know. We'll be glad to scan those and send them to you so that you can easily see the merging of the document.
All
October 7th for the second meeting. Do you want it back on the agenda on the 7th for discussion again, so that we can take any additional comments and,
Well, you can make revisions and things and give it back to us on the 7th. Just present it to us so that we can have it.
Yes, sir.
And that way, if there's anything else, we'll be good to act upon it then by the end of the month.
I think we want to attempt to meet our deadline for sure on our corrective action plan, so I would suggest making the changes and any input from us and trying to do it at that meeting.
We start that meeting at 4 o'clock.
the only issue in doing so is if we do that, it only gives us 2 days to get the information back, to have it assimilated and in the books, to go back out for the second meeting, because there's 2 weeks in between. We give you your books 5 days or so ahead. It's about time we're printing.
And where they are.
And we're there, because we moved the meeting up. It would probably be better if the board could just work on, again, up y'all, however you want to handle it, but we need enough time after we get input to make whatever changes those are and be able to get it processed through it in the books.
When are you saying you would need input from us? Tell us that.
Ma'am?
When would you need input from us to do it in the time?
Is there any way that the board can look over this and give input at the meeting on the 7th, so that we receive stuff back, or do y'all want to all discuss
That's
it?
what we're asking for.
That's what we're
We're trying to understand.
I guess the issue is what they're talking about is the timing of making these particular changes. And if it's permissible with the board, I think we can make those changes. I know I frankly will not be here for the next couple of days due to a family issue, but, we certainly would be able to have them by Monday if we can.
No, what's brought up now won't take any time, yeah. That's not an issue.
And I think that's what Mr. Kessler was saying, was go ahead and change the language of the things that we've already brought up. Any additional language that we see, because there's a few things in here that I see, go ahead and make those changes and then pass that back out to the board. Simply put the item on for discussion, and you will have those changes incorporated to look at. And if it's on the next one for discussion, then hopefully we can get through those pieces and then have the final on the next one.
By the second.
Yes, sir.
I think that's fine. We'll get feedback that night, we'll be able to make a change.
And that'll meet our deadline?
And that I believe will meet our deadline. Yes, ma'am.
Okay.
And you go ahead and send out the things for the travel policy.
Correct, I'll send the travel, the financial, or Ms. Johnson will travel, the financial, and the board, if there's any further questions, we may cover that night. The board policies, as you see, it looks completely different from the one that y'all just approved earlier, but it's really not all it is reformatted. It had grown to a point, like a lot of things that we just sort of stuck stuff in, that it didn't flow really well. And there's something in this section really talked about from 4 sections ago, so it has been largely reformatted. The only real additions in this one, red line.
Just 3 of them.
No, I thought we did. Yeah, the first is there's been some discussion amongst the board and among staff as to whether or not the board wanted to formally adopt some form of parliamentary procedure. This document contemplates that. On page 9 of 70 in your agenda materials. You'll see number 3 is parliamentary procedures. And what this particular document, and this is certainly one of the things we want to discuss with you. According to the way the documents are written today, the board will follow the ACCG's publication of parliamentary procedures for county settled petition 2003. And then if a point of order is in question, it defers to Robert Rules of Order, because Robert Rules is much more in depth than the ACCG publication. Now, I want to point out to the board at this point, I don't know how many of y'all have ever read that document. You may want to do so before you make this decision, but it will fundamentally alter the way this board functions. The parliamentary procedure that it discusses is not the way we do business. For instance, it requires a motion before any discussion. So we don't discuss and then make a motion like we do now. The board would have to make a motion either for or against, have discussion, and then possibly have to go back and amend that motion if the discussion changes, whatever. In other words, you may say, I make a motion to approve said item. Then after discussion, you determine you do not want to approve said item, you have to go back and amend that to, deny the item. So there are some things that will change. Again, it's up to the board. If we want to set a procedure, we can certainly do so, or we don't have to.
Do you have to have a second to the motion before discussion?
No,
Just a motion.
just a motion
To put it before the board for discussion.
yeah.
Then you call for a motion, then.
It can almost work the exact same because you make the motion and then you have all the discussion and then you amend the motion.
It could. There are some other intricacies in there. There were some things about addressing the chair only. If you want to speak, you have to do it through the chair.
But I have to recognize you.
Yes.
I cannot not recognize you.
It's a lot, it's a lot more.
Yeah.
It's hard.
Is that in the procedure?
Well, what it does, a motion.
It stops this
It
right
frames
here.
this right here, that's what I'm saying. That motion frames.
It stops this right here.
Yeah.
Is that the ACCG publication
Yes, sir.
you talking about?
Yes, sir. Okay. And if y'all don't have a copy, we can certainly provide one to you. I'm sure most of you clerks have it.
She said.
The clerk has a copy. I'm sure you do, but again, maybe everyone wants to familiarize themselves with that before the text, before we take action. And then the only other things we need to know who our parliamentarian is going to be. We got to have a parliamentarian to keep us in order when we get out. Because I'm sure I'll be the chief offender of that. There's your $5, Chairman. The other additions to this, since last, is on page 1270, item 3 again, publishing and posting. Sorry?
What page? 12.
1270, yes, sir. Number 3, publishing and posting of actions. We just put in your board procedures and summary of the items will be posted within 2 business days to comply with the law. Again, it was one of the things in the audit. We do it, it's just in these policies. And then additionally, section D, tabling, is completely new to this policy. There is an existing tabling policy that the board has. This is, again, seeking to add this to consolidate, to get rid of a separate tabling policy and put it within the board policies. And there is some differences in the language between this and the existing tabling policy. This differentiates between zoning actions and non-zoning actions.
Yeah.
Where the other one really didn't. It wasn't very clear. And then did we, what did we do with the date specific?
The question there was a discussion on date-specific tabling. In the aforementioned policy and procedure ACCG handbook, they recommend that if you're going to table it, you table it to a specific date or event, meaning we'll hear this again upon receiving this. They recommend more erring towards the side of removing it from the agenda and adding a stipulation to staff to return when you get feedback, when you get information, instead of saying, we'll turn it around in 2 days and get it back on your next agenda. You can also address tabling in the same meeting. So if you wanted to table to the end of the agenda or the beginning of the agenda.
And this is number 2 under that agenda items. If you look at the whole section, this motion sets a particular time for the item to be considered, which is later in the same meeting, at a future meeting, or upon the occurrence of a specified event, e.g. issuance of a report, which may clarify. So the particular policy in front of you allows tabling to an event, not a date specific. Again, the board may not want to do so. So those are the real areas that have changed that we're looking for input from the board on as to how you want to function on. I believe that is the only differences in this from what you approved earlier in the year, other than it's been completely reformatted.
Personally, I like tabling it to a specific time, whether it's at the end of the meeting or whether it's like we did before to October 7th meeting. Because if somebody comes and takes the time to come to hear an item and we decide to table it, I think they are entitled to know when we're going to be looking at it again.
So we could do that by just removing the part about upon a future occurrence. It'd just be date specific.
You could do either, because it may be an internal question that nobody else has published.
state, let's table this until such time as, it all depends on the event and the occurrence and the item, because it might be going to take 3 weeks. It might, somebody may present something that says,
My
it'll take a
concern
while to
is,
figure it out.
Mr. Chairman, was there are times when the board will say, let's table this to the next meeting. And I think in the middle of the meeting, it's not necessarily thought through, that like Adam said before, if we work on a 12-day cycle with 14 days between meetings, that's 2 days after the meeting. And sometimes, although the board in your head thinks it's 2 weeks out, that's plenty of time to do this, we as staff only have 2 days to have that particular event occur. And so we end up getting to the next meeting and tabling it again. And when we have that same risk of people that then showed up. So that was the thought behind it. But the other way to fix that is to say, we can't do it in 2 days, let's table it 2 meetings. So there's, certainly work.
I think that's what we depend on, having adequate staff to give us that direction.
At one point in time, we talked about looking at the date that things were gonna be due also.
Well,
Did you
that's been
adjust
done.
it?
That's been done, yes, ma'am. Matter of fact, that's what y'all approved earlier in the year, which language is still in this document.
Okay. We got anything else?
That's all I got, Mr. Chairman.
All right, so we're gonna have that information sent out to us so that we can rehash this on the 7th. We good? Consideration to approve the first reading of a proposed truck traffic ordinance. So we can give the sheriff enough information or teeth that he can stop these folks from using the wrong road.
The board has discussed a through truck ordinance for some time with the goal of providing safer roads and protecting the county road system. This ordinance is fairly kind of dry, trying to make it short and simple. If you'll notice, I believe it's only 2 pages. Trucks cannot use the roads listed on Exhibit A, which we'll discuss momentarily, once posted with proper signage unless their route starts or stops on the road. Heavy truck parking is prohibited on roads and rights of way. Heavy trucks may not enter or drive upon subdivision roads except for making deliveries. Current residents of subdivisions are exempt. Violations carry a penalty of $1,000 or 60 days imprisonment. Staff is seeking recommendations on what should be included, what roads should be included on Exhibit A. Staff considered just listing all county roads, but we felt that would lead to unnecessary signage on certain county roads, especially if it's like Golden, isn't that Golden was another example? A non-cut-through road where it's just a dead-end residential type traffic. We didn't feel like we needed to sign those. But we also felt that the written ordinance would require proper signage. So in order to write a citation, we would have to have proper signage, which means we need a list of roads that we were actually going to sign. Exhibit A can be amended by resolution, so that it won't require 2 readings to amend the Exhibit A. So if the board, a board member had a road that they wanted added to the list, you could simply ask that the resolution be brought back up. We could amend the list 1 meeting, and you're over and done. So we'd like to talk about that. This is a first reading, so Exhibit A can be amended between the first and second reading. And the only other amendment that we need to make is there's a correction of the citation that Mr. Morgan correctly found. It should be paragraph 3 of the Georgia Constitution in that section, not 2. The cost of the sign, when more than 4 ordered, is approximately $49. So that would mean you'd have to double that for each road. And if you chose to sign intersections with that road, that would be additional signs as well. If the board desires a through truck ordinance, staff recommends approval of this.
I got 2 questions. I think $1,000 cap, you say it's capped at $1,000. I think that's what it's steep and 60 days in jail too. But anyway, years ago, they had signs, like one right here on Stillwell Road. You just have a little sign there, county maintained, weight limit 56,000 pounds. And that's really all you need.
That's correct. The reason that we went this route was twofold, and I'll address both questions. $1,000 is what's allowed by state law. It's the maximum. It's not a minimum. It's not a minimum. In talking to our state court judge, the average fine for a failure to follow traffic control is $68.
How's it determined?
I'm not sure you'd have to ask him.
Okay.
I just asked what would the normal fee be. He said it's up to $1,000. Our normal failure to follow traffic control devices is $68.
Okay, that's fine.
The problem with the weight stuff, can't maintain 50,000 pounds, is we don't have anybody who can, or actually, we can't have anybody anymore that can do the actual weight of trucks. You have to call the DOT, and they're just not available like they were. But that's why the weight thing, that's why, Sheriff actually talked to us before, remember, about the best thing to do would be to do a sign type deal and put some bite into it with a fine or whatever to make it where it wouldn't, people wouldn't abuse it. But the last two big wrecks we've had in the county on Blue Jay Road, trucks, at the intersection there, on the road that they shouldn't be on anyway. Sheriff, if you don't mind, are you familiar, I'm told that state law says that a truck can use the road, the county road, to leave where he's picking up or delivering to, obviously, where he's picking up at. But when he gets to a state route, he's to take the state route, right? Not cross the state route and continue on a county road. Is that right?
That's a DOT rule. Put you on the spot, make you stand up and speak. We'll put you on the record.
Okay. Jimmy McDuffie. I think that's a DOT rule, not necessarily a state law, but it does require you to go to use the shortest route to a state route. And in a lot of cases, coming down Highway 21, coming into Effingham and turning on Kildare Road, get 119, it doesn't cut it. They got to come into Springfield and turn and go back up 119. So they're supposed to use the shortest route to a state route.
The way I had a DOT guy explain to me, and the way he explained it, I asked him specifically, he said it was the whichever direction that he was leaving, like say if he was on, let's just use Blue Jay Road, and he come out Hodgeville Road. If he was going towards Guyton, it would be acceptable to use the county road until he got to a state road. In other words, they wouldn't require him to turn around and go back to Highway 21, but it would be the direction, the first state route they cross, they're supposed to get on the state route.
So could they take Midland Road, or would they have
to
cross most of Road 17
and I've always heard it was the shortest, but the DOT guy told me, he said it was in the direction of travel. So,
about a year ago, we ran into this with one of the logging companies in the county, and we actually went before the judge with it, and they said it's the shortest route to a state route.
Okay.
That's what they told us. Now that's been a year or so ago too, so it could have changed since then.
I think it's a little vague on that, but
I was under the impression it was the most direct route. And the example I've used is if you're on Union Springs and you're going to south, hypothetically, you could drive all the way to the county line without getting from that road, without getting on a state route. So then the most direct route would be across Berryville or something like that, cut directly across Indigo Road, something like that, cut directly across the 119 and then hit south.
And as far as delivering, if you think about Old River Road, you coming off of US 80, and you're taking a log truck into the mill there, Georgia Pacific.
I think it's changed.
But whatever, if your officers can show that they're delivering or coming back from delivering a load, then they're legal on that, even with a 56,000 pound limit. But y'all would physically have to follow that vehicle to be sure that they actually delivered.
What? You wouldn't actually prove it, but in most cases, if they're delivering to that location, they can give you an exact location they're going to.
Okay.
But if they're just cutting through, they don't have a destination.
yeah, if it's a container truck, it's in the scales, because there's no container deliveries in that area. That's pretty obvious.
Now, Adam, this ordinance looks like any trucks with more than 6 wheels, so a truck tractor, you could not actually drive a truck tractor because it's got more than 6 wheels without a trailer. Correct?
We can clarify that definition. It does say with more than 6 wheels except vehicles or operators of local origin. But I mean, that hypothetically,
But
be a dual.
What I'm saying is if somebody drove their truck tractor to their house on a county road, they would be in violation of this ordinance, the way it's
No,
worded.
because there would be
It
a
addresses,
destination, a pickup or destination on that road.
it addresses that.
But I do think that perhaps we would need to do it because hypothetically a dually could be,
That's on
has 6 wheels.
Right. More than 6 wheels.
More than 6 wheels. So it's actually asking for the 7th wheel becomes the problem.
You try to have 10 wheels.
Now, yeah, let's say if you had a tractor with, you know, the sprayer on the
You
side.
try to
you'd
have 10
7
wheels on it. But I don't think.
But I don't think Jimmy's guys are gonna pull that over.
I wouldn't think so either.
Yeah, you know, we're talking about tearing up shoulders of roads too. Just right back to Old River Road there in 80, by that store, the little spur through there. You see those trucks parked on the side of that road all day long. There's no parking signs already there. But nobody enforces that. Are y'all not able to enforce that?
I think we could probably enforce it. Most of the time, that truck stuff, they lead to DOT and motor carrier compliance down there. And of course, they come and go, you know, they may be there today, may be gone tomorrow, but most of that's left up to them.
But mostly what we're after with this ordinance is trying to keep these heavy trucks off of these roads, using them as cut throughs.
And you'll notice, we took a stab, and you can see how far it is. On Exhibit A, those were roads that I thought that I had heard somebody mention at some point. So if there's roads that you think need to be on there, please let me know. I mean, that's just,
That's what I was gonna ask you, because I saw there's 5 roads on Exhibit A.
All right, Cloud Stillwell Road.
Clyde still is on there.
That would be only from the railroad track to Cloud.
Well, we need to know that.
That's 2 roads.
Are you talking about changing the name versus?
No, it's Springfield Stillwell Road till you get to the railroad track, and then it goes from, Stillwell Road to Clyde Road. That's 2 different roads, really.
So please, that's the whole purpose of Exhibit A. Let us know where you need them. We knew Blue Jay, Midland, those different types of things needed to be addressed.
Yeah, that is one. Does the board want Blue Jay on there? Because that's one of the reasons we held off on the Blue Jay McCall project, was we had anticipated increasing the capacity of that to accommodate trucks. So if we're going to then pass an ordinance prohibiting them, I don't want to do that.
Well, or prohibit it, and then whenever we get it where we can amend it. You know, once it's built to where it can handle it, then
You don't want to go into commerce.
And I actually have that in my notes that, the intent of this is not to limit commerce, it's actually to protect the roads and make them safer.
the intent of this is to stop the guy going over there and loading chickens at Ebenezer and running through the woods down Blue Jay Road in the middle of the night, running through the stop sign in Colorado.
Several years ago on Blue Jay Road, we had a fatality, and it was geared toward what the big trucks had done about eroding the shoulder of the road. Young lady traveling out of Lincoln ran off the shoulder of the road, dropped her car in that rut that was basically created by a big truck. And once she overcorrected, she went across the road, hit another car head on, and killed her passenger. I mean, that was a direct result of those trucks eroding that shoulder.
Sheriff, has your department reviewed this to tell us whether or not it's got everything that your office would need to?
We've been back and forth with Adam. I hadn't sat down and actually looked over the document, but I think we've all pretty much agreed, and I think it's something that's doable and needed.
We also did think it was important to add a letter that was addressed at the advent of Fort Howard. And it does say that we will allow 48 foot and 102 foot wide trailers in the county. And we further certify that Fort Howard Paper Company should choose to construct in Effingham County. The use of these trailers will always be permitted on all roads leading to the Effingham County site.
Yeah, so I mean, obviously.
But obviously, Old Augusta was built to those standards.
Yeah, but I would think that would probably include, Rankin Stillwell and Fort Howard too, because they lead to the site, maybe even Chimney. We may have a hard time prohibiting on those roads.
Herb Ketchup's not really one of the ones.
Kind of stuck out as a soul.
I mean,
something that you didn't want to limit?
It's not really one, it's a big,
Just didn't see what.
I was thinking cut through, that's how that
but
came.
not necessarily for the trucks, for big trucks.
Is there anyone else in the audience that wishes to speak to this item? Have any input?
And there will be a second reading if we vote to approve it.
Right.
I'm really hoping that there's a list of roads that are coming from someone at some point.
So what we're talking about, this is the first reading, and you're going to come back at
The next meeting.
October 7th.
the October 7th meeting with changes for the second.
With a list of roads.
Hopefully with an approved exhibit A.
Okay.
So I would put it on the consent agenda, I would just put it on.
Is Midland, I mean, we already have some roads that have the signs already on them.
Midland Road is built heavy enough for the trucks to run.
So we need to put those on this list. I mean, what's the road over at the end of Sand Hill Road, to the left?
We've gone back and forth with these because Midland Road is one and Blue Jay is one where it's actually a cross road. It handles, you know, it goes almost across the county in some way, shape, form, or fashion. Maybe the best route. So then if it's built strong enough, we probably shouldn't limit on the direct through routes. Like Blue Jay, you're probably right, we probably prohibit it now until it's beefed up and,
Yeah,
you know, it can accommodate traffic.
That's the problem now. Two things is the road's not built for these heavy loads, and it's failing exponentially. And then the other is the safety and the issues of the width of the road, like Sheriff's talking about, is, until it's at that point, you know, and surely, I agree, the east-west corridor is a big project in the future, you know, that we need to address, but right now, it's not. The road's not. Okay.
Midland Road would be fine.
Yeah, and that, one of the questions we were talking about, like, was on Midland, was it built as a state road or to those specs? Mr. Morgan asked the same question about Old River Road. When it was originally built, they had state GDOT numbers. They might have not been constructed by that, but were they built and spec'd to meet state road standards? So,
The understanding that I have, very superficially, is that Midland Road was intended to be a state route, and that the state came in and did a bunch of maintenance on it to get it to state route standards with the intentions of going across the swamp and into, like Jimmy Lopes. That was going to be the Effingham Parkway, if you will. And then they abandoned that idea south of, I guess, 30, and then turned it back over to the county. Fairly correct. So it probably substantially meets GDOT standards, but it's not, you know, obviously it isn't GDOT, right?
and it seems like sometime while I was here, GDOT contemplated taking another county road or state road and flopping it back and forth. Maybe, you know, they would accept, we were asking them to accept a county road as a state route. They said they would, but we have to assume one of theirs in order to make that transfer.
That was
And
275, they wouldn't do it.
Correct. And it was to receive the big money off of their payment.
So do you
We
have a
were gonna
recommendation
swap
on
it too.
it? Does staff have a recommendation on
Recommendation on,
Truck routes.
Midland?
Should we do Midland? Should we do Blue Jay?
my opinion will be Blue Jay and Midland. Midland do not need to be prohibited from vehicles. Now, Blue Jay has some issues. Once Blue Jay is, you know, made sufficient, I believe we need the east-west corridor. Now, I understand that at the time, it probably needs to be precluded until such time that it can be brought up to those standards.
And I would like to caution you that that's a 35-mile-an-hour speed zone through there, through Midland and Blue Jay in that intersection. And we write a ton of tickets there every single day, and we kill people there every year. So let's keep that in mind as well. I know trucks need a route, it's a better road. That's why we have the wrecks like we have.
Thought, Sheriff, this is on your committee reports. GDOT just completed a traffic engineering study for that intersection, Midland and Blue Jay. Now, you know what, get your opinion on it also, perfect time. They had two recommendations. One is to trim the limbs away for sight distance. One is if you're coming out of Lincoln, when you pull up, there's two poles right there to your left that you cannot see around until you're well beyond the stop bar. Looking back to your right, all of this except the power poles and stuff the county can handle. We just need to do some maintenance. The second suggestion they have is to make that a four-way stop. So that was going to be, and it's still on committee reports, to ask this board what do y'all want to do? Do you want to make it a four-way stop? And since you brought it up, I'll get y'all's input. Do you believe that that would be beneficial? I'll put you on the spot, to improving safety in that intersection, if you make that an all-way stop.
I think
Is
you're
that
going,
what GDOT has suggested at this point?
I think a four-way stop would be a great idea, but I think you're going to increase in magnitude your complaints on that road because it's always been a through road. I don't know if that might not lead to more issues until you can get it down to that. I think we need to clean that intersection up a lot
Yes, sir. I agree.
and try to market better. But it's been a problem since I've been here 26 years. It doesn't seem like whatever we do.
Well, sight distances are horrible. I went out there recently and stood physically at the stop bar, and you can't see anything. You have to, you can see people, they pull up, the back tires of the stop bar by the time they get where they can see, and that's just extremely dangerous. So, we can certainly handle everything except power poles, and I believe we can probably get the power company to move those through some form of influence.
Up until recently, most of our crashes at that scene were coming from Lincoln, going across Blue Jay across Midland and coming up Midland. People would say, I saw them stop. They stopped and looked at me and pulled right in front of me. And that happened a lot up until we had these recent trucks that just blew the red light, the stop sign completely.
Well, we're talking about safety, and we're harping on safety, and that is a big portion of what we're talking about. But we're also talking about premature wear on the roads. And we don't have the money to repair all of our county roads. So part of this is also protecting the asset and getting more longevity out of the roads we've got. Cloud Kildare it's starting to move exponential, just like McCall did. McCall was bad, got bad, a little worse, and then all of a sudden it took off. And that's what Cloud Kildare is doing now. It's you start to see the gators and the cracks and stuff, just like Log Landing Road. Remember when we did the decel lane, we talked about a few spots in there. Now almost the whole section back of the bridge is gated, the whole thing. So if you don't do something, it starts moving exponential. So safety is a big priority and concern, but it's also protecting the asset. And Cloud Kildare is one that is a logging shortcut for South Carolina loggers. That is just what it's turned into.
Well, the damage needs to safety.
That's right. That's right.
Well, like I said, there's lots of roads. Little McCall Road, Sandhill Road.
But Blue Jay Road, as we move forward and the road can get widened and 4 lanes and improved, yes, I think that would be a great east-west corridor. I think that's even part of the Effingham Parkway, IDA expansion, But today, it's not, and it is a problem out there. And the road is failing exponentially fast.
We'll make those additions and any other suggestions the board has, please send them to us. We need to be back on 7 with a list.
But you're needing a first vote tonight.
Yes, ma'am, I think we'll vote one way or the other. Now, if you vote
And when we
against
vote
it.
tonight, we're voting on the list that's in front of us, the exhibit A, or what?
Well, you're approving the first reading of the ordinance.
Not necessarily this list. I don't think Robert Kessler really is a truck priority.
We can make any changes between 1 and 2. For second reading.
And in the future, any changes will be made to the exhibit, not the entire ordinance.
By resolution.
So the question I had though, on the roads that are listed, the roads that we currently have no through truck traffic signs on, don't we need to add those to this list?
Well, I need to add, pull the signs down, yes, sir, 1 and 2.
Honey Ridge Road, and whatever the name of that road is over there on Sandhill Road.
I know
There's one that signs over there now. At the end of Sandhill near a
Oh,
Turn
Dogwood?
right, and take
turns left.
Turns left, Dogwood.
Yeah.
Yeah, it goes back a.
It's signed.
There's not a new one down at,
But
Just direct staff, or we have to have signage to add to it?
Oh, yeah.
Nelly Road.
Please.
yeah.
Well,
Yeah,
We still don't have any signs in there, do we?
I thought
you're not going to enforce this until you get the signs up on these roads, right?
That's correct.
Okay.
Correct, I believe we can by law. It has to
I
be
think
signed.
ours, I think you need to put a piece in the Herald and the Effingham now also.
The other reason that when we were going through this the first time about the resolution, that comes from MUTCD, which says selective exclusion signs that give notice. We have to give notice to road users that state or local statutes or ordinance exclude designated drivers. So we had to have an ordinance to enforce. We couldn't just go out and put up signs willy-nilly.
All right. I have a motion to consider the approval of the first reading of the proposed road traffic ordinance.
I'll make a motion to approve alternative number 11.
Second.
Motion and a second, all in favor? Any opposed? So carried. Item number 7, consideration to declare various items for surplus.
From time to time, the county has equipment and vehicles that are no longer needed beyond the useful service life, broken or damaged. These items must be declared surplus to remove them from our inventory insurance and to properly dispose of these items. We have 2 lists for your consideration tonight. The first is from the Public Works Department. These items are either no longer needed in a state of disrepair or primarily used for road construction. The purpose of surplusing these items is to obtain a reasonable value on each item with the intention of selling them and using some or a portion of the proceeds to purchase new road maintenance equipment for the Public Works. Greg Burns will be assisting us with evaluation of the equipment. Once sold by auction or sealed bids, the proceeds would be returned to the appropriate fund, and use of the funds would require board authorization. The second list contains vehicles and equipment in the general fleet. These vehicles are either in a state of disrepair, have been scavenged for parts, wrecked or damaged, or the cost of repair offsets the worth of the vehicle. These vehicles would be disposed of by auction or sealed bids, or disposed at scrap value. As always, the proceeds of the sale will be returned to the appropriate fund. Some of these vehicles on the Public Works list are completely functioning and working. They may not be in the best condition, but they're working. So the idea here is to sell those either at auction or by sealed bid, take the amount of proceeds, return them to the finance office or to the appropriate fund, and then from there ask that those funds be reallocated to road maintenance equipment purchases. On the second one, mostly these are for the most part, I don't want to speak for each and every one, most of them are not running. Some of these are wrecked vehicles. Some of these have no doors. Some of them have no dashes. We're just trying to clean up the lot and get what we can for them so that we are our own junkyard, which it appears on some days we are.
Did I hear before possibility of trading some of this equipment in for new equipment? And can we do that?
The idea is not to trade it for new equipment. The idea is to sell it and use the proceeds from the sale for new equipment.
By trading it, we mean we would have to dispose of it, sell it.
Were you asking was trading an option?
Yes.
And that's what he was asking.
That's what I'm asking.
On new equipment?
Yeah.
I don't think legally we can do that. I think we have to do it a surplus by law.
Yeah, I don't know why they're doing
Is that right?
But I'm not sure.
Yeah,
I think so.
Unless
I'm pretty sure you have to.
you have to surplus it
You have to surplus it.
regardless.
I think unless you do the deal in the
We're having to
beginning
declare
where they
it's
guarantee
surplus.
the buyback.
Yes.
In order to trade it, you have to declare surplus.
I understand
And
that.
I don't know the answer as to whether you can trade it.
But then you're saying, you're not asking this board to authorize how to dispose of it. You're just asking us to declare it surplus.
That's correct.
Once it's surplus, we want to get someone to look at it, tell us what value we have, and from that point, we'll know what sort of options, if it tells us we got $20 worth of equipment, we're not gonna buy, $10,000 worth of other equipment. We're trying to make it traded.
Or whether it's worth more for scrap metal than it is for.
Yes, sir. The idea is to take some stuff that was primarily used for road building, that we no longer do, and replace it with road maintenance equipment that we indefinitely need of.
I think a smart thing to do with that first list is contact Ritchie Brothers and let them give you a quote on the whole thing. I can give you a rep's number, but they'll bid on the entire package. That'd be good.
I thought you were looking at me about the last it's time we surplus to just some trailers. Because I know the chairman had asked about taking COBs, if they're working on it back now, that will have lot numbers to sell those trailers.
That's basically designating as surplus, removes it from our inventory, which
At least you do evaluation.
Now, just for my own clarification, now that we've had some additional discussion, does this board want to, do we need to bring this back to you before disposal? Or does this authorize us to dispose of this equipment by law?
Nothing don't change, is it?
What's our cost?
We probably don't have one around.
We don't have a surplus.
That's gonna be a fair dollar amount on that first list.
Typically, you allow them to.
To be completely fine, I think we can handle that. We have not taken sealed bids, but we'll be experimenting with sealed bids on the trailers that you guys surplused in March of this year. However, with the auction, we've had success with reserves. We'll try to seal bids on the big stuff, see if we can't sell it all by package. We can try gov deals and see if it sells that way.
Typically, though, the auction company Greg Burns works with this kind of equipment, it's not what they do. Those are farm tractors and all, but not that big.
Well, he's not even having an auction around here this year.
Not this
We
fall.
have to haul it to wherever the other ones are. The only thing he offered to put a value on it, we said, fine, that's the only commitment we're making is you come by, tell us what you think it's worth. That was really just to get an idea of what we thought we could replace it with. It certainly wasn't the disposal method.
That bid should be 175 to 200. Even though the 5,000 hours on that D6.
I don't think it needs to come back to us.
Well, basically, we're trying to replace it with a mini excavator, a little small roller, maybe a small walk behind asphalt distributor, something we can begin to do larger patchwork with.
I agree.
Well, to clarify what Adam was saying, I simply asked one day, whatever happened with the seals, with the bids? And he said, well, this stuff's still sitting there, it never got bid. So, now it's become part of this. All right, now I have a motion to declare these various items on these two lists surplus.
Make a motion to approve alternative number 1.
Second.
Motion and a second, all in favor? Any opposed? So carried. Consideration to approve an amendment to the Aging Services Contract, 2014 Contract, 2014-08.1.
If you remember earlier this year, you approved a contract with Aging Services that allowed us to provide for our senior meals. We did get an amendment on this from them, which actually reduced our overall funding. This is something that's quite standard with them, based on what the state and federal government is giving to them. They do adjust this. Sometimes it's once a year, sometimes it's twice a year. This is the adjustment that they have sent as far as the approval of funding for the aging services meals. And so we simply ask for your approval of this amendment to the original contract.
Any question? Motion?
make a motion to approve staff recommendation, alternative number 1.
Second.
Motion and a second, all in favor? Any opposed? So carried. Consideration to approve budget amendment for the purchase of patrol cars for the sheriff's office. Anybody here want any cars?
I think Jimmy can speak to what his needs are, and then we'll go through the financial piece of it.
We have, in the last 2 weeks, we've lost 7 cars. 3 of those to transmissions, 1 of them to a computer, 1 of them to an electrical problem, and 1 of them to a crash. 2 of them to a crash, I'm sorry. Young lady just hit a ditch on East Road the other night. I'm sure with the age of the car, they're gonna total it. So we're getting in dire straits. We picked up 2 cars we purchased a couple of weeks ago. Those we paid for out of inmate funds where we could, inmate boarding. And we've got 4 we got to pay for, and we've asked for about a total of 20. That would leave 14 more that we're asking for. At the rate that we put miles on these cars, we average about 300 miles a night on a car. By January 1st, I'll have 24 cars that have over 150,000 miles on them. 12 of those will have over 200,000 miles just by January. And then we still got to go from January to July for a new budget to kick in. So we're getting down to the point where we don't have a choice. There was a request submitted with our budget. Somewhere down the line it fell out, got misplaced. We asked for 28 cars in the budget, it didn't get there. So now we're having to do something else. As the old football player says, we got to back up and punt. Joanna says she knows exactly where all the money can come from, and she's all got it planned out. So.
The 20 cars, does that include the 6 that?
Yes.
All right, so you're talking about 14 more.
Yes.
Go ahead, please, Joanna. Tell us where the money comes from.
Well, one of the things, when we went through this budget the last year, we did note to everyone that the capital items had been pulled from the budget, and that we thought that perhaps out of contingency funds that we could fund some of those, or that we needed to further look at those capital items. I think this last year we actually bought 6 during last year to go ahead and replace what we had. So out of that 28, I think that he had listed, we had already taken care of about 6 that we knew of. So this is the remaining 20 of the 26, 28 that Jimmy had asked for. And looking at it overall, several weeks ago, we made a budget amendment where we increased our contingency funds by $299,000. So we originally had $150,000 within contingency, and we just added another $299,000 to that. One of the things that we've looked at is the cash flow of trying to actually pull all of this together. And so we looked at the possibility of going ahead and leasing some of these. And by leasing, I mean that we actually pay for it by lease over the next 5 years. In doing that, we basically requested information from several of our lending agencies and found that we could get a pretty good rate on about $1 million. It's basically 1.65, 1.89 for the period of 5 years. Out of that $300,000 that we're talking about that we added back to the budget because of the different savings that we had in the health insurance, the 2 cars that Jimmy already has that he did as an emergency to replace what he had, those 2 cars are coming out of his existing budget with regard to the jail boarding. So we have those 2 particular vehicles covered. The additional 4 that I believe that he has, which that funding has not been issued yet, is another $90,000 that he needs for those 4. Part of this lease piece of it, though, is the fact that we can't technically take possession of those. In other words, we need to make sure that we already have the funding in place and that we issue and have those invoices issued in conjunction with that leasing program. In other words, they would put those funds in our account, and those funds would be directly paid out of that account for those pieces of equipment. So we have to do those pieces a little bit differently. And looking at that particular funding, we basically would have something in the nature of if we did $1 million, we would have something in the nature of 209 in payments per year, or about $17,000. With the fact that we've already paid for the 2, and we're basically needing to cover the 14, we would need somewhere around $600,000, which means that that would be about 60% of those payments, or somewhere in the neighborhood of $125,000 to $150,000. If we look at using, yes, ma'am, per year, correct. if we look at using that $299, we could go ahead and use the $299, $150,000 of it to cover the first year worth of the leases, and then turn around and use the other $150,000 to pay for the 4 cars that he has currently, along with whatever equipment that we would need on that. And looking at it with Jimmy, one of the things that we looked at was, you know, what's going to happen the following year and the next year. I think it's the consensus, at least of the sheriff's department, you know, Jimmy, that if we go ahead and purchase the additional 15, what that basically does is we bought 6 last year. We've already got 6 on hand right now, plus another, you know, 14 or 15. That would allow us basically a totality of about 26, 28 cars. We feel like that would, and Jimmy, correct me if I'm wrong, but we feel like that would basically allow us to get through the next couple of years with a payment of around $125,000 to $140,000, and then we would not have to worry about replacing any cars until that 3rd year. We would have to look at it again. That means that we currently have the funding right now for the first year. We would have to additionally come up with $150,000 in the budget for every subsequent year of those 5 years. But we feel like that would at least address Jimmy's immediate needs and put us more in the 3rd to 4th year of trying to look at it again at that point.
Well, I was just trying to figure out, that'd put us around the 2015 budget year. I think this next budget cycle we go through, we could probably eliminate some in that, provided we don't have a bunch of wrecks and a bunch of crashes. With the new cars, we won't be totaling out as many, hopefully, because when we bump a deer, which we seem to do at least monthly, they won't be totaling our cars, so we can get them fixed, put them back on the road. And that time we'll just have a maintenance cost. Won't be as high maintenance cost because the car will be in a lot better shape. And I've got some reading material here that I'm going to give y'all too, to show you some of the recommendations from our maintenance staff and from my patrol division about the safety of these cars. And I'll give you that. You can take it home and read it in your spare time.
Well, and the other thing that Jimmy and I talked about was 2 other points, and that is, for instance, the items that you just surplused, some of those were patrol cars. That funding certainly can go back against these purchases, along with you know, whatever items are deadlined out of the ones that he's replacing. Also use that particular revenue, whatever it is, to go ahead and help fund some of this. It may not pay for a great deal. It may pay for maybe a month's worth of the actual payments.
Were all the ones that have been recently wrecked, were they in that surplus list or not?
No.
Okay, it's another issue that we talked about that Jimmy's mentioned is when a car's totaled, that money has not been going back to the sheriff's department, and we'd like to see that happen as well, because go to the cars.
Those funds basically are attributed to insurance proceeds. It goes back into the general fund. And in some aspects, you're already accounting for that money simply because we know that there is the propensity for that, along with the propensity for wreck. So it technically is budgeted. It is not budgeted necessarily back to his particular department.
So that is something we could do.
Yes, certainly.
You know, I don't get too much for those cars that he's turning, all those companies.
So,
They done use most of the parts and the other, the engine is gone, so you're not gonna get nothing to justify.
I think the last time we got somewhere between, Adam, correct me if I'm wrong, somewhere around 500 to 1,000.
Yeah, it was on the scrap page.
That surplus is what you're talking about.
Correct. I'm just saying that might pay for some of the light equipment, it might pay for a few items.
so Sheriff, how many years do you get out of a car roughly? From the time you buy it, how many years do you think you get out?
Some of these cars on this list go back to 2004, 2005.
But an average,
Normally what we like to do is we use that car 3 years on the road, it gets about 100,000 miles out of it. Then we roll it over to school resource officer, civil process, some of them, and we try to get another 3 to 4 years out of it with them. And of course, we hadn't bought cars in a long time, so we've been dragging it out, as they die.
So would you say 6 years would be?
I think we get 6 years easy out of one.
All right, and how many are patrolling? How many cars do you have total in the fleet, in the patrol, and what you would use the cars for?
I don't have
Not-
a clue
not
off the
just-
top of my head.
I think he's talking about patrol.
Yeah, patrol cars, and then for the life of the car, you know, all the way down to school resource, how many are we talking about cars total? Roughly? Not exactly, just roughly.
We got 28 that's on the road every day. That's actual patrol cars, high speed, responding to calls.
Yeah, I don't, and not necessarily every car, because some of them are on duty that day, maybe, but a day, I guess. What I'm trying to do, because I believe that I remember doing this one time before what I was doing, and we should be on a rotation of about 5 or 6 cars every year should be bought. Is what I believe I remember. That's where I was headed now. Because
When I
we
first
know we got so many cars, we know we get about 6 years out of the car, then we should be budgeting an amount every year for replacement of cars. And I believe last time we did this, it was 5 or 6. I believe, I'm not certain.
That's what our plan was when I came in office 2002. We were not as bad a shape as we are today, but almost. We were doing 15 cars a year for 3 years, and then we were going to go to the 5 cars per year minimum. Well, budgets didn't let that happen. We've done 15 cars, I think, one year, 12 one, 7 the next, and then whatever we could talk somebody into after that. We got 28 cars that actually ride patrol at high speed on a daily basis, well, monthly basis. They're out there 15 days.
And things like that, right?
I'm sorry.
That does not include
No.
detectives and things like that.
And see, with detectives, we can roll back to if we go with a Charger, we can go back to a V6 Charger for them, because they don't ride high speed very often, which would save us gas mileage and save us cost of the car. The main thing right now is patrol cars that we've got on the street.
I do agree, and I know we don't have to get into all the math tonight, and I know that one reason we need 20 now is because we have not budgeted over the last few years for the cars. But I do completely agree that after we get past this point of what you need right now, we need to establish some type of regular rotation every year and budget it. If we know you need cars, we should budget for them. I agree with that.
And that's what I was getting at, is we need to budget this.
Right.
We need to come back and have a budget amendment later.
I agree.
Why it wasn't in the budget remains to be known, but it wasn't, so, but we've talked about this for years, and I know that for the past 2 or 3 years I've been involved in it, we haven't been buying a lot of cars. The majority of the cars have been bought because of the wrecks and stuff, not necessarily for rotating out, you know, routine.
And some of these cars that are surplus, what we've done is rob doors off of them, rob fenders off of them, rob hoods off of them to keep what we've got going. And I showed Mr. Floyd today some of the cars and what they look like because of trying to keep them on the road. And they're getting to be pretty rough.
And you're recycling the light fixtures and things like that.
And everything that we can use off the car that we've got that we can put back into the new ones, we're trying to do that as well, because everything that we can reuse.
But we missed out on not buying those last Fords.
Well, if we could have bought those Fords, we could have used everything from one car to the next, but.
Is leasing common with police cars?
Actually, it is.
Really?
Other
There are
municipalities.
some companies, that, you know, I went through about 5 or 6, some of them will outfit the entire piece of it. In other words, the lights, the radio, the decals, you name it, it comes totally done.
You can get it for less than 2% interest. This is one thing we did here.
Go through the math again. What would the board be approving?
Basically, the information that I originally got from the bank was on the terms of $1 million over 5 years. The lowest rate that we got was 1.65 on that. From what I can tell right now of the scenarios that we've got, we would need something like around 600,000, 650,000 of that. In doing that, the math shows those payments will be around 125 to 130,000. On the other side of it, Jimmy currently has 90,000 that we will need to pay for. along with whatever equipment. So my thinking was that out of that $299, we would basically have somewhere around $125,000 to $150,000 on the 4 that he currently has that we would need to go ahead and pay for because we've already done that. And then we would use the other $150,000 to cover the first year's worth of payments. And we of course would not need all that at this particular point in time because we're already into this budget. But certainly the $150,000 would cover the remaining of the $650,000.
Okay, let me ask you in a
But
short
you're
way.
wiping out your contingency altogether.
Let me ask you in a short way.
This is the additional contingency that we have on top of the contingency that we already have. This is the
Added
budget.
contingency.
All right, so to answer my question, we're paying for the 4 cars that you have invoices for right now
Correct.
out of contingency funds, not out of the lease.
That's correct.
So that's 4. 2 of them came out of his budget.
Correct.
That makes 6.
Yes, sir.
We're talking about 20 more,
No, 14.
14
to
more.
15 more.
And if I understood right, you were basically saying that we've been approved for $1 million, but you're talking about borrowing 600 to 650
Correct.
and using the balance out of contingency.
Correct.
Or another flip side is you could borrow $1 million and not use contingency, but either way it would work.
We technically though can't, I don't believe we can borrow all of it out of there because we've already taken possession of these and we've already paid.
That's my question.
Okay.
The 4 cars is not an issue, that we have to pay for them.
I don't know whether or not, I know that once we actually make payment for them, they will not do that. I have not clarified with them that since we have not technically made the payment, whether or not they would allow that to go within the million.
Well, personally,
Yes, sir.
I'd rather take those 4 out of that loan as well,
If we're able to do them.
if we're able to do that.
Yes, sir.
But then Jimmy's office recognizes, y'all had a discussion, he recognizes not to take possession of any additional cars until we get the paperwork, so that we can put it to the lease.
That's correct.
We move forward with this, we're gonna order the cars at whatever time we get it approved, and those cars are 8 to 10 weeks out
Yeah.
from even being delivered at that time. So we're looking at a 8 to 10 week span after we even ask for it.
But it'll let you get them ordered and begin the process.
I think the difference today is that we need y'all's approval to go ahead and move forward to secure the leasing amount, and then have those documents ready so that we have that in hand prior to making that purchase, if we can.
There's 14 times 39,000 is 546,000.
I rounded it up at 40 times 15, I think.
Okay, well, that's what I was trying to do
Yes.
math, because we're talking 14 more. Or we could do, if we were able to throw the other 4 in there, then we would be talking about 18. So does this board need a dollar amount to approve to apply for this loan?
I think
Or
that,
to apply for the lease?
I think we can get up to $1 million, so, at the board's discretion, yes, sir, we need to formalize those documents, go ahead and secure that financing, and then move forward with the actual process of the purchase.
Well,
The motion so that it can include the either or, that's what.
that's what I would like to entertain. Get them back on the road. Any other questions, discussion? I'll entertain that motion.
How do you want to make a motion so that we cover the amount? How many cars is it? 14 or 18?
14 or 18, yes, ma'am. 4 that are already in possession and 14 more to purchase.
At what cost?
The prices range and it will be dependent upon that, as to whether or not they are somewhere in the range of 22 to 25,000 per car, and then additional equipment up to the potential of about 39,000 for everything per car.
And that depends on how much you can scavenge off of the 32. 18 times 40,000 would be $720,000.
I got one more question then.
18 times 40.
Since we've approved this deal with Motorola, with new radios and all the communication stuff that we just had to do, will that be used for the radios for these cars? And will these radios be the new standard, the new compliant, or whatever? Because we certainly don't want to put radios and electronics in the car that's not going to be compliant with the tower upgrades.
Well, right now, radios that you'd be moving from one vehicle to another.
As much as possible.
Yeah, they require a software update, but the radios will work. There's a few scattered around that will not work, but so I don't know exactly what's in these cars.
But what I'm saying, the price is obviously for electronics in the car too.
Are you buying new radios or taking the radios out of the existing cars and moving?
Everything that we can take out, we're taking out.
So
We're trying to get the dollar figure there, so in case we have to buy a radio.
But it's like a separation cage. The ones in the Crown Vics would not fit in the Chargers, so you have to buy that.
So I had to buy all those new. I think in most cases, we'll be able to move radio to the car. Now, whether it's compatible with this new stuff they're coming out with and all that, I'd have to get that
Well, that's
from
what
somebody
I'm
else.
getting at. If we've got to have another radio or a new radio, then we just want to make sure that that's one of the new ones that's capable of this other stuff.
And if we transfer over, we'll make sure that's doable. Now, we could buy that radio at that $2.9 million, and that would help offset these dollars.
That's what I was getting at. Is that included in that 2.9, you know?
Would
The upgrade of the software was.
Would $40,000 per unit cover vehicle, lights, siren, radios, everything?
He's got on here.
I think that would be everything, buying everything we need to cover.
And is it a fair statement to say that some vehicles is going to require all of that because we don't have it to rob? Some of them we're going to be able to come under that.
Right.
So if this board was to authorize the lease of up to $720,000, that could cover 18 vehicles. If we could get those other 4 in there, you may be able to rake and scrape enough parts and pieces off of radios and stuff to save enough even to fund another car.
Was any of the ones recently read documents?
Hadn't been that lucky yet.
When did you have the 7th one? When did you have the 7th one?
Saturday night?
Oh.
One of the things, I think is important too is Jimmy is looking to try and save where we can save and looking at the V6 versus the V8s, especially for the detectives cars. We worked some figures on that, and the difference in gas mileage alone over those 3 to 5 years, we will basically pay for 1 or 2 of these cars just in those gas savings.
But on the other hand, there's some vehicles that you may need Tahoes for that's going to cost more because the Chargers just don't accommodate what you got to do with it.
Well, and those are going to be limited in scope. That's what we're trying to do right now is get back on the road.
So does our motion need to include, for the purpose of the covering everything, does it need to include the 2 other cars that he's already paying for in the other way and address that, or not at all?
That's already covered within his budget at this particular point in time. I would think that if the board made a motion to say that we could secure financing up to, say, $750,000, and as Mr. Kessler said, if we can get those additional 4 cars in there, we will. If not, then we will pay for those out of that $299,000. The difference covering the first year's worth of payments on the leases of those that we can lease.
Because we're already taking 150 out, somewhere thereabout for the first year's lease payment.
Yes, sir.
So for clarification, does my motion need to include the fact that if the 720 doesn't cover everything, the rest will be taken out of the contingency?
It should cover it.
Or not?
Yes, ma'am.
18 vehicles times 40
She raised it up to 7.
But she's trying to help Jimmy, she's trying to get another bid. And I don't have a problem with those. It doesn't take long, you walk over there, you look at what, I think everybody needs a new vehicle, except David, he says he don't need one. Wasn't that correct?
Heard he backed into a lady with the van the other day.
I think that was improper parking.
That was a personal car though.
Any other questions, discussion? Motion?
720 or 750?
If you make it, if you're gonna make a motion, it's your motion.
Okay, I'll make a motion that we approve $750,000 up to $750 for leases of 18 vehicles. If it does not meet that, then we can take the balance due out of contingency. That's my motion.
Second.
Good. Just to clarify, you said for 18 vehicles.
One more, if we can get them out of it. You want that?
Well,
Flexibility.
flexibility.
18 plus.
Vehicles and equipment up to 750,000.
Yeah.
And let's clarify the motion as to the lease payments will be coming out of contingency, as well as if we have to pay for those 4 vehicles out of contingency.
You want me to restate?
I think so.
Okay. Let's try again. $750,000 for the lease, up to $750,000 for the lease payment approval. Any balance necessary will come out of contingency, whether it is for monthly payments due or to purchase.
Have that amended motion. You good with that with your second?
Second.
All in favor?
Aye.
Any opposed? So carried.
Thank y'all.
When we going to get another?
8, 10 weeks.
Well, not that they don't need them.
That ranks right over the bottom of the radios. Something you may got to have.
You got it?
Sure don't like them.
Don't like spending it.
Am I in jail?
All right.
Yeah, if y'all get people just to be good, we can take money out of jail, just not build so much jail.
That's exactly right.
Don't keep the cost.
Yeah, you want to talk to them about the state changes, is how they're making more big county inmates rather than state inmates?
Try to avoid that conversation and get some mad about it.
Okay, I'm sorry.
That'll fill up the new jail, so we'll have something to do with it. I just want to pass along to y'all, I don't know if you heard about it or not, but this may be inappropriate, but I wanted you to know it tonight. We had a crash this afternoon where a 17-year-old South Effingham high school student was killed. So we've lost another high school student already this year. But I didn't know if y'all knew about it yet or not, but I
What
wanted to bring
caused
it to
it?
your attention.
You know what caused the wreck?
High speed. Basically what it looked like, the comment was made, I bet I can get 100 miles an hour on Bay Road. And I don't know if they succeeded or not, but they didn't stay on Bay Road.
It's terrible.
And her brother was the driver of the vehicle, and he's in intensive care at Memorial, so. That's all.
That's terrible. We might lose another. Well, just for what it's worth, I'd love to see y'all sit down on Collikelmy Road every afternoon. Boy, I tell you what, it's a racetrack. And my wife asked me, she says, you have no pull with it? I said, no.
We get county commission to buy some more radar and put them in cars.
You're done.
We
We don't need to buy nothing else.
We just passed that for cars and equipment.
Okay.
All right. Direction on how to proceed with county ownership and maintenance of unaccepted subdivision roads.
If y'all want more explanation clarification, I'll be glad to give it.
I think
If you want to look for direction.
Well, my direction would be for staff, and I'm speaking for myself, and then if the board wants to, is for staff to work with our attorneys to look at each and every road as to what ordinance was in place at the time, and, how those, whether or not we should say that those roads were already accepted or not, so that we know then how to proceed. Because if it is deemed by our attorneys that we have already accepted those roads, then I think that list needs to be brought back to this board, and we need to take whatever actions necessary to finalize that.
I agree. And Thomas, well, it's 150 plus roads. How many actual subdivisions did you say it was?
57.
Okay, so technically that's what you'll be looking at is the subdivisions. So 50 plats or whatever.
But I think we need a good clarification on each one as to what we got and take action on it.
I agree.
Now,
Okay. Was there something we
Y'all
said?
can stay till the end of the meeting.
y'all get a call.
Cold strong.
I had the fire alarm go off.
Donut sign came on.
Yeah, hurt your feelings, Dave. Just
Gotta
gotta
be hungry now. What are we talking about?
Is there any other board member he's asking for direction, is there anyone that wishes to
No, we got
differ
it.
with that other than,
What kind of
That
service,
sounds
time
good.
frame on it, what time?
Something, I mean, just to,
Yes.
keep it moving.
Not the next meeting, but the next.
and I don't mind, I don't know how big of a task that is to pull that out, whether we can accomplish that by the second meeting in October.
Well, the ordinances aren't gonna be too hard, it's not like there's been, you know,
Right.
100 updates, but
That's
it's
right.
just a matter of pulling plats and looking, see when everything was reported.
Then is it direction of this board to have staff move in that direction and present back to this board by the second meeting in October?
Yes.
Yes.
Is that possible? Legally? Can you do that?
Probably. If we can't, we'll let you know.
We can have a time lapse tracker for this
So directed.
plats.
Thank you very much.
You asked for direction, you just got direction.
We appreciate it.
Item number 11 is added. Would you like to make a formal presentation of the facts in that?
Sure. You saw vote, since nobody's here.
Or I can wing it.
I'm gonna wing it, but I'll try to try. The law library passed a resolution, and it's not dated, so recently, anyhow, we were just provided with this Wednesday, the day the books went out. The books had already been printed when we got the resolution. Deeming, $50,000 of funds that they have excess, and what the law library would like to do is to give those funds to the county, and to have the county do a budget amendment to whereby we can fund the Superior Court, Drug Court in the same amount, $50,000. There's a couple of issues with that we've dealt with internally as to how to make this work, and possibly rather than going into all the issues, it may be either that Elizabeth and I spoke earlier. Under the current resolution that's written, I don't know if the county has any mechanism to actually disperse the funds that are provided to us. However, another option here may be, rather than doing that, to go back to the law library and ask them to pass another resolution, which basically says that the Board of Trustees of the law library hereby authorizes the following purchases. And then we can go, which is the reason that you all have pieces of the budget in front of you, is that we can identify specific purchases totaling relatively $50,000, and we can have them authorize those purchases, that may be the way of doing this. And skip around, y'all should have a section of law in front of you. It's 3615-7. If you locate that and find it, what the resolution from the law library says is they have excess funds as per 3615-7 subsection C. And subsection C gives two mechanisms for spending funds deemed excess, one of which is given directly by the Board of Trustees to a charitable tax exempt organization for the purpose of providing civil or legal representation for low income property. We're not the Board of Trustees, we can't do that. And if any other funds are left over, they're given to the commissioners. And then it specifically says that those funds shall be used for the purpose of fixtures and furnishings for the courthouse. We have nothing in our budget for furniture or fixtures in the courthouse. So we have no way to dispose of those funds. Subsection A allows at the discretion of the Board of Trustees, payment for purchases made by the county's names 5 courts for the purchase or leasing of computer-related legal research. So those purchases made by each of the courts, it may be that if we had them write a resolution that says, the Board of Trustees, which is what they've done here, in this resolution, hereby authorize the following purchases, we may be able to legally spend those funds. Whereas the way that it's currently written, I'm not so sure we can.
Basic toss, hit it right on the head. The way the resolution is written, they are giving us the funds pursuant to 3615-7C. The board can't expend those funds unless it is for fixtures and furnishings for the courthouse. And funding the drug court is clearly not purchasing fixtures and furnishings for the courthouse. So the only workaround we can find would be for them to give us a list of what they need. The board could accept the funds, give it back to the Superior Court, and then they could make the purchases. That was the only way we could figure out how to basically solve this problem. We presented that option, I believe, to the law library board and haven't heard anything back from them. We're just given this same resolution again. But how it's written now, we can't really work with that.
So would it not be a fair statement, if this board wants to take action tonight to give the drug court $50,000, it would be basically to simply be giving them that as a funding, and there is no mechanism in place for us to be reimbursed at this particular point.
Right, there is no mechanism in place right now to take the law library funds and give it to the drug court. The board could elect to.
If what you're advising us is that what is being asked of us is not legal, then
I mean,
it's a clear answer on that.
Fund the drug court some other way, but not the way we're asking.
I think either way, we're going to have to fund the drug court with general fund dollars. Any funds that the law library gives back to us are just to replace some other, but it would require budget amendment. We would show an additional revenue source and we would decrease we have to do a budget amendment. But we would still be taking general fund dollars. We can't use funds from the law library to fund the drug court.
Bottom line is, this money accumulates in this fund and the judges want to use it.
Yes, sir.
And the county, at one point, from what I understand, when the judicial complex was being built, there was money in the budget for that construction for furnishings and fixtures. So at that time, this same thing was done. They took that money out of the budget for the furnishings and fixtures at that time, and then that money was diverted and put into something else. And I think they're wanting to use the same scenario to do this financing. And as far as my review of it, there is no legal way for us to take those funds from the law library and use them to specifically fund this drug court. And we've had meetings and gone around this thing, and this commission was trying to help by moving date funds to by basically becoming the agent for their grant, and by paying the bills in advance and then waiting on our money to get reimbursed. So the only issue before this board, I think, this evening is not this resolution, but whether or not this board wants to fund in some fashion the sum of $50,000 to the drug court. I think, does staff and our attorney feel that's an adequate statement?
Yes, sir.
I think
I
so.
do. Can't speak for our attorney.
So, if this board wishes to take that action to exchange those funds, number one, we have to figure out where to get it from. And I see no legal way to be getting that from the law library.
Are you still talking about taking the 50 they're giving us and holding that somewhere else until it can be legally used? Or can we not even take it?
There's no way for us to take the funds.
Okay, that's what I figured if we could hold it.
Okay, how about right here at the bottom on D on this, OCGA 3615-7? Of course, I didn't read all of subsection B, but it says all law books, report text, periodicals purchased by the use of gifts from the funds of the county law library shall become the property of the county.
Yes,
So they say they buying books and stuff, and if there's any money left over, the county gets it anyway. So we can't turn around and give it to the court.
No, that provision, part D is just saying that anything purchased for the law library is county property. So,
Just saying we own it.
it's just saying the county owns the law library property. It doesn't account for transferring funds from one entity.
So that's just stuff that we own the property,
Right,
but it's not the money.
right, it's just the physical property that they buy.
I
didn't know why it was highlighted, really.
The law library funds, as I understand it, were originally intended for the codification of the statutes and these other things, periodicals, books, whatever needed to be purchased by the law library. This other is just kind of
I think it's also for software.
software.
Lexis, that sort of thing, legal research software, you can continue to renew the licenses for each year.
And there was nothing like that they needed that could apply?
Nothing in our budget.
There are some of those things, yes, ma'am. However, the resolution that they passed specifically says per subsection C, which subsection A allows those expenses. It's the way they passed our
Did
resolution.
we tell them that?
Yes.
Yes,
So that they had to redo it?
yes.
No, they did not redo it. We told them.
And unfortunately, I thought we were going to be here tonight so that we could have this dialogue on what happened.
The answer from the senior judge, basically, the way I understood it, that was relayed through another court judge, was that the superior court judge and another attorney would be here tonight to answer and explain how we could do this. They're not here.
It might be on the way.
I'm not saying.
Let's stop it.
You know, there's a lot of issues behind the scenes of all of this, but the bottom line is, does this board want to figure a way to give the drug court $50,000?
And to throw one more caveat in that is, included was an email in there that came to me from Mickey that says, as per Judge Turner. Again, it's still Mickey. It wasn't related directly to me, that if this funding is not received by month's end, he'll have to cancel his program, which is why this part, a lot of the reason why I added to the agenda.
We have been funded it.
Yes, sir.
We have been funded it.
But we've been funding it in a way that was reimbursed, is that what I'm understanding? And now, I want to be sure because I'm a little confused. Have we been funding it in a way that was reimbursed and now we're not?
They had an $89,000 grant that was a reimbursement grant So when we had a meeting with Judge Turner earlier this year, it was decided that the county could go ahead and pay their bills, correct me if I'm wrong. We could pay their bills and then we could become the agent under that grant. I don't remember that come before this board. I know,
Yes.
I thought it did.
Yes.
And I know then the moving of date funds into, we gave them $10,000 out of that. So we were trying to help their cash flow, because that's what they were having a big problem was cash flow. But for whatever reason that we don't need to go into, they did not reapply for that grant again. And now we checked and it's too late for them to apply for that grant, so now they're strapped for money again.
So again, in years past, how have we been funding it? Were we always getting that grant every year?
They've been getting the grant.
They've been getting the grant and they've been reimbursing us?
I believe the grant went directly to the drug court.
It has always been direct to them. We could
So we
just
were not
now,
involved until this deal? Okay. And now they want us to become funders of it, basically.
They gave 50 the first.
I think it's a fairly new program. It's only been around for a couple of years.
but I
We
think
funded
the
some
board
city
did
money.
give them a $50,000 initial,
Correct.
We gave them some money.
but that was
Correct.
3 years ago, two.
It's been 2 or 3 years. The board gave them some money, then there was a grant, now here we are, once again.
Just,
Did they understand that we were expecting the reimbursement out of the grant, but they didn't apply? Are we clear on that? Like, did they know that that's how we approved it?
Yeah.
We're getting,
Yeah.
we're billing for what we pay, and we're getting reimbursed from the present grant.
Yeah.
But that grant expires,
It all expired.
and now they're going to be broke. They don't have any more source of funds.
Basically, with the MOU for the grant is we cut the check back to them once we receive payment from the state. And the MOU was realized we could go ahead and pay upon their receipts as soon as they gave us receipts, and then we would just wait for the reimbursement. So yes, they understand we're getting reimbursement. And it was, I mean, matter of fact, it was out of $89,000 was what, last 10 of it or so? So, because, I mean, we didn't alter to the end.
Tulsa, and you can correct me if I'm wrong, Judge Turner and those involved in this, they don't get paid for anything, right? It's all,
I don't know the answer to that, Commissioner Hooper. Somebody's getting paid somewhere.
I think
Now,
so.
whether it's the judges or the.
they got a counsel that gets paid,
There's some
Judge
counsel,
Turner,
yes, sir.
Vicky Keegle, and those involved in it, the cases. And I went to one of those meetings him last year, year before that, well, I've been 3 years ago. We sat in that room and talked about it, and they did not get any salary. That was just to give them the time to do that.
Of the original funds that we contributed several years ago, we never saw any of the documents as far as invoices or what that went to. However, out of the funds that we are currently doing for the, or were doing for the grant, the only thing that was payable out of there, I believe, was there was some training. Most of it was counselor based, and then some drug testing. I did not see any salaries whatsoever except for the counselor and the administrator.
Yeah, that's what I remember, but it's been a couple of years ago.
And I can tell you that the hospital, correct me, the hospital has agreed to do their testing at no charge. We have prison counselors that I think we have offered possibly to allow them to use at no expense. There's ways we can help that drug court, but the question before this board is, Judge Turner is wanting $50,000. And whether or not this board,
Now, I will say this too, Chairman, the resolution says 50. In my conversation with Mr. Raffner, he indicated that there will be an initial transfer of 20 and 2 subsequent 15. So if the board did want to fund this with general fund R, I would not suggest you go to 20 because that was their initial request, is that it will be done 20 and 2 15. So obviously they felt that to hold them off for some period of time and would give us time to have further dialogue with the judges to figure out there's some other resolution.
Well, when all of this started, the fee was $100,000, and it was going to be 50 to go to state and 50 to go to Superior Court.
Correct.
And then Judge Thompson said, get Judge Turner happy and he can wait. And I just say that because I think the board needs to know that there's something else sitting out there in the sidelines. They supposedly have $100,000 sitting in this fund that they want to give the county, and in turn get the county to fund their projects. And I'm not saying the projects are bad. I'm not
I
saying
do hear they're a good program.
I don't even know about it.
And Jimmy, I wish he would still be here because he's got some real winners of stories of people that's gone through the drug court that have real success stories. Now you've got some that they were able to keep out of the system basically, and save them. There's some real losing stories too that you're going to have.
I think we can help them, I think we need to help them.
What do we have to do? 50? I mean, if we got the hospital and prison.
Were they supposed to be here? I
I'm
think
just over
that
here.
it's the 11th hour. I don't have all the information. I don't even understand this other thing that you're talking about. Don't know nothing about it.
Vicky told me personally he was gonna be here. I mean, it was passed down, they were supposed to be, I'm not sure what happened.
Judge Mosley told me that she had talked to Judge Woodrum, and Judge Woodrum stated that Mickey and Judge Turner would be here
And Vicky told me directly he would be here. I
to
don't know
answer
why.
any questions.
I talked to Vicky this morning to discuss it, and, I don't know if you guys wires crossed, he said he would be here if he needed to be here. I don't know if he expected me to call him to tell him to be here, but, anyway.
Anytime you want something to pass
You come.
anywhere, you better be there.
You're right.
Do we need to give them, or do we want to consider giving them some amount that would get them through another month until they can come here and actually give us a real presentation? So that they're not closing down? We're being, if I understand correctly, we're being told if we don't give them some money right now, by the
They're
next
gonna
7 days, they
stop
gotta close
the
down.
But did you say we could give them 20 and then 15 and 15?
That was their request, Mr. Lovey, yes, sir, was to give 20 and then 2 additional transfers to 15. Now, I don't know, maybe Joanna does, with administering the grant, what is their monthly cost to run the program? And I guess we could do it as 82,000 divided by 12,
I mean,
From what I could see, it was anywhere from approximately 5,000 to 8,000, depending upon when their bills came in. So I would think a sum of less than 10 would continue them for the next 30 days at least, until you can make some determination as to what this board would like to do.
I mean, certainly I think if this board is in mind to help the court, $10,000 would be more than adequate to get it through to another month to give us.
And then staff needs to make it clear in an email to them that we need them to come give us all the information we need so that we can have a full understanding, because we're having to try to figure out all of that.
yeah, I agree. And with the board approval, I would like to present an alternative resolution to them also of another way we believe they can handle this.
That's correct. Or, we're already talking to legislators to try and get the law changed. Basically the law library, rather than coming through a board of commissioners, the law library should be allowed by the statute to fund itself. These items, if the money can be used for these purposes, the law should state that it can be used for these purposes. You shouldn't have to be coming around an inroad like this to make it happen.
There's too many of those things that we're having to actually.
But I'm sure the law was considering, should a law library fund a drug court?
That's exactly.
That's.
Well, the governor put quite a bit of money in grant programs, and unfortunately, like you said, we're not able to apply for them. I said, the court wasn't able to apply for those.
Well, can you hold it long enough to make a motion?
Ryan, I just don't know how long we're.
The other way to look at that too is it's something that Mr. been some success stories, and they're spending $40 a day, you know, to keep someone in jail. you know.
Yep.
So, you know, a year, that's $1,400 or $14,000, $15,000. So for every person that you perhaps save from that program,
Bring us the information showing us that that's happening.
understood.
Okay, so
Anybody want to make a motion to fund?
I make a motion to go ahead and give them $10,000, and then they can come before the board. I'll keep them closing down, they come before the board, and then we'll see what else we can do on top of that.
I'll second.
Motion and a second, all in favor?
Aye.
Any opposed? So carried. All right, we'll take
To
a short.
clarify, those funds would be coming out of contingency?
Got to be, that's
Yes.
the only place they can come from. So find a way to get those cars and. All right, we're gonna take 5 minutes, then we'll have our staff report. All right.
But they're not on BOC.
Committee reports. Talk to us, Mr. Todd.
We've already discussed Herbert Jeffrey Courthouse, impact Westwood drainage, jail construction, you have another update attached. Building regulations, I'll bring up real quick that the Construction Board of Appeals discussed question mark. There really was a resolution, I just failed to type it in here. On Friday the 20th, this past Friday, the Building Construction Board of Appeals did meet. The vote from the Board of Appeals was to repeal section 37 and 38 of the ordinance, the building codes that were brought back to y'all, which are all the supplements to the state adopted codes. Therefore, on the 7th, we will be bringing back to the board a revised request to repeal 37 and 38 of the building code. That'll be on your agenda on the 7th.
Which basically will repeal everything other than the state mandated adopted code.
Yes, sir.
And then January, the new code will come out and be enforced.
Correct.
And then we can build upon that if there's any items that we feel need to be dealt with. And then submit it to the state for ratification, is that?
Correct. If there are any additions.
If there are any additions.
The past meeting, I gave y'all some proposed reorganizational type charts. I don't know if y'all even had a chance to look at those. I don't know if there's even any interest in going forward. If so, I'm assuming that's a front-room discussion. There's, no personnel, specific decisions. If there's any, desire to go forward, I guess we can add that to an agenda. So let me know if you want to or not. And if so, we can add it and discuss it. Sir?
I say second.
Second.
Let's get it for discussion.
Middle of the Blue Road traffic study we already discussed briefly while we were in here. Does the board want to convert that to a four-way stop? We'll think about it a little bit more, a little more. You have in your reports a letter from GDOT, a cover letter that simply gives the recommendations. There's a full report if anybody would like to see it. I'd be more than happy to provide that to y'all. It's just a whole bunch of numbers and stuff, but you're more than welcome to see it.
Well, I'm sorry, agree with Jim, and just cut the bushes back so you can see down the road. I mean, they got a light there anyway.
Yes,
And the DOT's actually, that they're looking at, that's what they're looking at doing at 17 in Blue Jay.
I don't know that, no, sir.
If I'm not mistaken, that's what Ann told me the other day, that was something they were looking at doing at, I could be mistaken.
And it could be, there was a traffic study done there also, that it didn't.
I believe she told me that was something that they were looking at, probably getting a recommendation on.
And we can certainly try that. If you look at the traffic study, there's warrants for those sorts of things, just like there are for traffic signals. That particular intersection does not meet warrants for a four-way stop. However, we recommended it, so, okay. We'll just work on getting all the, public works do like cut the grass around there, but there's some larger limbs and trees we need to take out.
Is there enough right of way owned to cut it back?
Yes, sir.
So we definitely need to do that. And
The one issue that I see, well, two issues. One, we're going to need to get those telephone poles moved. And we'll also go to power, we'll mention and see where we get it, try to force them back. The other one is if you're going towards Rankin on Blue Jay, to your right, there's a fairly large pine tree there that in my opinion needs to come out. It's in our right of way. However, those people have it decorated like it's part of their yard. We can certainly send them a letter or take it out. It's ours to take out. I just don't know if they'll get upset about it at all. But it is definitely within our right of way. And I believe it needs to go.
What's that guy's name? He works for Smatter Tire.
Brewster.
Brewster.
Woody.
I think that's a safety issue.
Well, since you know him and you so kindly volunteered to talk to him, I do appreciate that.
I'll call him, tell him we're gonna have to take it down.
Thank you very much.
Woody. Woody, that's his name.
And then the last thing is we have had brief discussions with y'all about the Rankin's proposal for Blue Jay and McCall to put a fire station there rather than a Hodgeville station. You have some information in your packages that shows the 5-mile radius map, that shows the proposed budget that Rankin has generated, what the additional cost would be to the contract. There was some attempted savings to the county. I'm not so sure whether they're 100% accurate. The question is, at this point, staff, I believe, has done all that we can do. We revised maps, we provided technical numbers. I believe it's a question at this point for the board. Does the board even want to entertain this? Is there, and I know we've got to be careful with committees and so forth, but is there some delegation of people that would like to begin talks with Rankin and their council to discuss some of this, to see if there's any merit to it or not? And I tell you, on the surface, the map as far as the 5-mile radiuses, it pretty much covers everything a Hodgeville station would operationally. I don't know that it saves us any money. In other words, the addition to the contract will probably be offset equally by what we would have to pay. The only difference that I see is the capital cost. We wouldn't have to build a Hodgeville station in the 2 trucks, which was the $400,000 station, $700,000 truck. So there is $1 million worth of potential savings in capital out there to us, but there's also some discussions about how the station will operate. We were going to do a 24-hour station. They're not really talking about that. They're talking about scattering some people around. Additionally, the Hodgeville station was supposed to house EMS. I have told them that. They've initially someone agreed to put space in there for EMS. However, I'm thinking about it. I don't know how our EMS would co-locate with the city fire station. There are definitely some issues to work with. So I guess the question is, would some of the board be willing to entertain those discussions and just determine if we want to do it or not? So that the city can, if we're not, so they can move on and do something different.
If there's a possible option for true $1 million worth of capital savings, it's at least something we should probably discuss. And considering that that station covers the majority of my district, I would want to be involved in that.
And I would say that it's probably worth pursuing to see. The first thing we need to do is get 275 station.
That was discussed through this process, and what the city has stated to me, again, there's no document, what the city has stated is that if we were to entertain this, they're looking for a long-term contract. If you look on the numbers you give, it was a 10-year projection. I know we need to do a 10-year contract, but not having a 1-year out, and they also believe that if they had it, they had someone to go with their trucks, that they would agree to either sell us the building at the offer that we made, and I don't remember the number, 189, I believe it was, or allow us to continue to operate the way we are without purchasing the station, which would save us some money that I'm not sure we need to pay. So we have discussed, I said it to Mr. Ford, but that's got to be addressed one way or the other in this agreement. So that was talked about. Now, again, it's going to require the board to do that. So again, I believe staff's going as far as we can. Additionally, we've talked about go ahead and solidifying any talks about annexation of the research forest tract and water and sewer. Rankin have approached us about some additional capacity in our treatment plant because they're at capacity with there, about purchasing or renting capacity with our treatment plant for their future growth over years or so. I have expressed to them a desire to wrap all that into one sort of deal, if you will. So there's some balls in the air, but again, I believe I need some.
The 275 station was agreed to by us and the city 2 years ago.
Yes,
The agreement was made, what to do, how to do it, the ball's in the city's court.
Understand?
And I'm not interested in getting any more fire service with them and more delivery area, more area or whatever, until we can get what we agreed to 2 years ago, finished.
Understand? And what I've been told is that they agreed to go ahead and do it for the offer. My question is just, is it in the county's best interest to spend that money? We will have to. Just pose the question.
They're possibly posing a better offer if we put extensions.
Well, they've agreed to continue to operate just like we are. And I guess, do we need the building for something? Do we need to spend $200,000 for round numbers to have them continue to operate the way they are out of that building? And maybe we do. Just a question. But I believe that they have all.
There's no reason to do it just because an agreement says we would do it if they're okay with us not.
Well, I'd be perfectly happy to sit down with them, but they already kind of understand my position. This is, it's just my feeling, this is still part of the wanting to annex those two tracts of IDA property. Because if they annex the second tract, that puts them out where this land is. And then the next thing's going to be back in here and asking for more in service delivery, asking for more money. And I asked, in the end result, is it actually going to save the county money? We may save upfront capital, but then they're going to be using it to justify additional costs to get out of splash funds.
That's a good question. And to be honest with you, what I proposed to them was some form of consolidation. And it didn't make it near as far as I wanted it, but I did propose that on multiple occasions. So I agree. And I'm not saying this is the solution. I'm just saying that there's a potential for $1 million of capital up front. It's maybe worth investigating.
There's so much to look at.
There is.
Sorry. With all the statements that were just made, there's so much to look at because that's just such a long-term thing. If they actually do take on more services and we're providing a lesser service because they've got another area, I mean, if that would occur, it's a balancing act. So we'd have to see all that long-term math and figure all that out.
That's right.
And I'm certainly not suggesting this is the solution. That's not what I'm saying. I'm just saying, do we want to go down the road to determine if it is or not?
I want to go down the road personally of trying to figure out how to work together and make wherever's going to provide the
And that's
best
kind of
cost
where-
savings to the citizens.
That's kind of where the fire was headed, remember, we were talking about trying to consolidate some fire and have more of a county-wide fire service, and hopefully some of the municipalities.
I don't want to give up on it yet. Mr. Kovacs typed up a nice report to hand to them as to how that could happen. So, we actually have a defined document now to say this is how it could actually happen. So, to me, that's what makes sense. It's not just continue, you expand your area, you do this. It's that consolidation. I'm not telling you we'll get there by any means. I'm just telling you that I believe that this may give us the opportunity to have that dialogue.
But at the same time, in good faith, if we say we're gonna do something, and we do it, and I'm talking about the station again, we agreed in service delivery as part of our negotiations with service delivery, that the fire station, we were going to get an appraisal done on it. They didn't like the appraisal we had, so we had them do an appraisal, and split the difference.
I don't think it was so much that, they admitted later, that it was more of a concern that if we purchased that building, that we would then cancel their contract, and they would not have anywhere to put their engines.
We need to just
And
have
that's
a
what they
good,
agreed to.
open dialogue and find out if there's any possibilities of consolidation and where those possibilities are. And then see if we can work towards it. I mean, I'm on record for, I'd love to see a countywide fire system with countywide water. And so, I mean, consolidation of services, I think, is the best way for us to go. Rankin needs to connect. I mean, because unless they keep talking to EPD and giving them more and more, they need. I mean, we can go above 119 and do things, get out of this Savannah agreement, and if we could get Guyton, Rankin, everybody on board, we could make a good countywide system.
Consolidation is the answer for every
Consolidation.
They're not going to
Making
get
it,
to
bringing it all
They
together.
can't even go to they can't go to either Floridian well now.
I'm not,
EPD done cancel all that.
but then again, the EPD just gave 100,000 gallons to the folks put a water park in Bowie.
They already
For Illinois.
They already had the,
No, don't
You
even
don't
go
think
there
so?
with me.
I got a letter I just got from them saying that nobody, not even farmers can drill a well.
But to answer your question, I'll be happy to sit in on the discussion, and I do have an open mind, regardless of what they say.
In terms of, I'm not naive enough to believe this is the answer, we've got to move on now, but I do think it's probably worth the dialogue. Worst thing we're gonna get to the end is not gonna work, but when we write the law, because they can't do the station without you all approval. You know, that's first service delivery, so.
Well, the good news is there's a dialogue,
That's
and
right.
there's no pending deadline date by a judge, under the gun, so there's some, little bit of.
That's all I had. If there's some desire to move forward, I appreciate y'all's willingness to do so. I'll begin to set up some meetings to see if we can get some of their council involved also, and we'll see what happens. And that's all I have for committee report. So, money.
Anybody else got anything?
I got 2 or 3 things. We got to vote for delegates for next week between you and Farm.
Well,
A voting delegate for this county platform.
tell
You only
everybody,
got one
tell
vote.
everybody what it's about.
You only got 1 vote. Well, I did it for 8 years, I guess I can do it again.
Does that need to be added to the agenda? We're gonna vote on the
They just, no,
You don't need y'all can flip boards on the way up there.
Well, Randy, since you're our delegate to the CRC, I think that you're the adequate person to be doing that.
And also, I gave each one of you this thing about the DOR, where they want to get down and cheat us out of some money on these ad valorem taxes for new cars. You can read it, call your congressman, call the ACCG. And this is the fast thing here, the same 100 years next year, I'll be with ACCG. We don't have our meeting, across the river over there, the convention, and, anyway.
Hutchinson Island.
Hudson Island, and they taking pictures of all the hotels, it's getting late, of all those courthouses. And anyway, they don't put them all on the inside of the trade center over there. And anyway, but to get involved in this, it's gonna cost us $1,500 for people. And we get the picture then, it's on the campus. They've already taken pictures of the old courthouse. But if you let them know something by November the 30th, you get $100 off, it costs $1,400. They say it is a nice picture on the campus, of the old courthouse.
Well,
Get it in somewhere. But anyway,
you put it on the next agenda to vote on it, but
All right.
now move it.
well, I just thought I'd tell you about it. Yeah,
We can look at the courthouse, we don't have to have a picture of it.
well, whatever.
$1,500.
I'll do it for you.
Anyway, that's all I got. That's all I have.
Anybody else?
I was gonna tell you, I was noticing the other day after we were talking about cutting the grass in the median down in south end of the county, north end of the county, actually, the grass is head
September 10th, 2013. We have two sections there. We adjourned and went into executive session at 6:24 and adjourned at 6:36, in which all commissioners were present. So I'd like to vote, motion to approve those minutes.
So moved.
Second.
Got a motion and a second. All in favor?
Aye.
Any opposed? Carried unanimously. Next, I have the executive session minutes for the same date, September 10th, 2013, in which was called to order at 9:16, in which Commissioner Jones was not present. All other commissioners were present. I'll entertain a motion to approve those minutes.
So moved.
Second.
I have a motion and a second. All in favor?
Aye.
Any opposed?
Abstain.
So carried. With the record noting Commissioner Jones abstained from voting because she was not present. Any other business to come before this board?
Make a motion to adjourn.
I have a motion
Second.
and a second. All in favor?
Aye.
Any opposed? We stand adjourned.